opening of the technical people, the private respondents were allowed to participate.
Tomorrow? Okay.
My lord, item number 4.
Same.
My lord,
Same, I know one of the.
Tomorrow,
my
am
lord,
I taking up this bench tomorrow? No. Okay. Tomorrow.
my lord, item number 4 for time being. Time being. Item number 4.
Time being means what time being business?
My lord, my senior is now put number 5.
It is still at the stage of mentioning. You mention about time being when the matter is taken up, not before that.
Don't get patient on the ground that the person who deals with the matter is on leave. So for his leave, you cannot wait for until indefinite period. So it may kindly be listed tomorrow.
What is the matter about?
Matter is transfer of Bajaj Insurance Company employee from here to Chhattisgarh. Due to some dispute between the employee and the local boss.
Is it bench 3? Isn't it bench 3 matter?
Yes, no, basically. So, this is the bench.
Not tomorrow, day after. Tomorrow is Tuesday. Why tomorrow?
Because we have filed it on 2/2.
So what? It will be day after.
We issued that will create problem.
Not tomorrow. There is no urgency. You could wait from 2 then what is there?
Even then, I mean, very.
Day after.
May I also please, I wish to mention item number 34, my lord. In this case, I have entertained my appearance for respondent number 7, 8, 9.
Item number 34, what has happened?
34. Environment fee is here with its consent. Yeah.
For
File the affidavit. File the affidavit.
Mhm. This type of adjournment I don't permit. When the matter reaches, we'll see. Next.
Regarding the taxes, regarding the employees of the tax, yes, my lord. From my lord, 20 of June itself, otherwise, my lord, excellent. Affidavit has been accepted, that is complete. For admission or other.
Admission, it will come.
My lord.
Service is complete. Okay, 2nd of March.
May I please? Matter is the eviction matter, madam. May be listed tomorrow.
Why?
Eviction matter, madam.
Eviction.
The file starting.
Eviction, if you can bring it today, I'll take it up today. Mr. Counsel, if you can bring the matter today, I'll take it up today. Have you filed it or not? What is the filing number? Okay, if it is filing number is there, then we'll take it up today. Hatti? Why?
And then the file there is no stay of that number. That's why I mentioned.
Gradation difficult. We'll see when the matter reaches.
My lord, listing of a motion item tomorrow, my lord, eviction matter.
Tomorrow. What matter?
Eviction matter, my lord.
Eviction, can you bring it today?
Today it will be,
Have you filed it?
yes, my lord.
Then what is the problem if you have filed it?
My lord, then we will try. I will try my best.
Eviction matters should be done immediately.
My lord.
If it is not there, then it is there tomorrow.
Obliged.
Okay, what is the matter about? Okay, have it on 27th of February. Motion? Day after?
The lending matter of the amount of compensation will be released. In the last occasion, I made a clear on this normal code policy. The allowance was supposed to be listed today, but it should not be listed. It will be taken up later tomorrow.
Bench 5. Bench 5. Bench 5, I am the senior today. Okay.
May I please, Your Lordship, in item number 36, my lord, we have filed an additional affidavit that is not in record. May I kindly call for my.
Or? Okay, day after.
Please, Lordship, I beg to mention for listing of a matter, admission matter,
What matter?
and eviction matter.
Okay.
Eviction.
25th.
Supplementary is for item number 49.
Why? They have received the money. Ms. So-and-so appearing on behalf of the petitioner submits that the petitioner have received the ex gratia payment and as such the petitioner would not like to further proceed. Ms. So-and-so appears on behalf of the Revenue Department and Mr. So-and-so appears on behalf of the District Administration. Taking into account the above, the writ petition therefore stands closed as infructuous.
Item 50.
Same.
Yes, sir.
Same order.
Item 51.
Same. Same ex gratia.
May I please, Your Lordships?
What is it? Huh? This is also ex gratia.
Lord, my biryani shop was sealed, my biryani shop, was sealed by the deputy commissioner, now the petitioner says that they will approach the disseminate. They don't want to press further.
Mr. A.R. Bhuyan, the learned counsel appearing on behalf of the petitioner submits that the petitioner would not like to press the instant writ petition, taking into account that the petitioner now would approach the respondent authorities. So-and-so appears on behalf of the respondents, who's taking into account the above, the instant appears on behalf of the animal husbandry.
May I please, Your Lordship, I am on behalf of Animal Husbandry Veterinary Department.
She appears on behalf of the Animal Husbandry and Veterinary Department. Taking into account the above, the instant writ petition stands closed on withdrawal.
Lord, I think all of it arises.
There is already there.
This is item 1, Your Lordships. I am appearing for petitioner in this matter.
Yes, what is your matter about?
Well, this case was listed before Your Lordships on 12th of December 2025. The issue is that despite the notifications issued by Reserve Bank of India, the respondent number 5 was attempting to forcibly recover the vehicle from me. And we approached this Honorable Court. The Honorable Court issued notice and directed us to serve HDFC Bank. Mlods on 15th of February, Mlods on 12th, we also issued a notice and I have appended the receipt before Your Lordships. But they had an audacity to recover the vehicle forcibly in the manner in which we were apprehending on 15th of December 2025 from Nagaon, a place called Borgat. And this is not just in violation of the Reserve Bank notifications, which has a force of law. It is also contrary to the recent mandate of Honorable Supreme Court of India, wherein the Honorable Court took a very stern notice of this kind of a practice, wherein the vehicles are recovered forcibly.
Now, the vehicle is with whom?
With us, sir.
With respondent number 5, Your Lordships,
You-
HDFC Bank.
I am HDFC.
Okay. Now, he says that only an amount of rupees 2,86,000 is
No,
remaining,
your lordship, total outstanding is 18 lakhs.
18
And
lakhs.
besides that, what he is doing, he has changed the number plate of the vehicle. That is AS1 RC 6571. And whereas the vehicle is in this case is AS01 PC 0167 is the hypothecated vehicles. So without paying the EMIs, your lordship, that account has been declared NPA. Thereafter, we have issued notice and we have pre-intimated to the Thana concerned, and it is not that we have forcibly taken away the vehicle. So what the Supreme Court has said that we could not able to forcibly take away the vehicles, your lordship. That we have
How did you take the vehicle?
Yes, your lordship, first we will send the notice to the borrower, defaulter, and thereafter we used to intimate to the Thana concerned, and thereafter on track of the vehicle, we take the vehicles, your lordship.
So he came and gave the vehicle to you.
No, your lordship.
Then how
He
did you
does
take
not
it?
came because he concealed the vehicle from us, your lordship. That is the case, he concealed the vehicle from us.
Understood. But did
And
you
even
help?
doesn't
Did
allow
you
us to
take the
inspect.
help of the law enforcement?
Yes, lordship.
No, Your Lordships, no help is taken. Vehicle was on road. It was taking a commercial consignment and they recovered it. This allegation that we have changed number plate is an alibi to recover the vehicle. If number plate was changed, how did they identify the vehicle on the road
From
that
the
this is the vehicle
engine
which
number
we
and chassis
wanted to by forcibly stopping it? And no notice with regard to repossession has been issued to us. Giving an information to police is akin to that
Your
I'm
lordship,
committing
allow me
murder
2
and
days
I'm
time, I'll
informing the
put
police
the
authority.
entire things on affidavit, including loan agreement, clauses in the loan agreement, everything, your lordship.
You put it.
No, your lordship, just allow me 2 days time, I'll put it on affidavit, your lordship.
The principal issue is not that how could they forcibly recover despite the fact that they were well aware that the matter is pending before this honorable
Some of
court.
the documents lying at the central office, so just 2 days, your lordship.
They were aware for almost 2 months now that the matter is pending. Even then they could not get it from their concerned office.
And Panchnama, that inventory was also prepared on that day.
Okay, let us issue notice.
Yes, sir.
Plus, they may be further restrained from alienating the vehicle. They are likely to
Don't
dispose
alienate.
of.
Don't
They
alienate
would.
till we decide.
The principal reason of recovering it, the manager intends to give it to some concerned person at a lesser throwaway prices. That is the principal reason of recovering the vehicle. Otherwise, they would not have recovered it. What the general practice is, the moment it is recovered, the manager in connivance with some persons sell the vehicle at a throwaway price for erroneous consideration. That is the principal reason. Otherwise, I was making the payments. They were required to issue me a notice with regard to possession also, even if we believe their fair practices court. Whereas no possession notice has been given to me. They could have gone to section 9 petition, section 17 from arbitrator, anything they could have done, but they stopped it on the road and they've taken it. Now they say that he changed the number. If I change the number, how did they got to know that it is this vehicle which is on the road and they have to stop it?
What is this annexure 2 which you have enclosed?
May please, Lordships. We'll
Annexure
just
2 to the writ petition.
let's annexure 2 is an inventory with regard to the vehicle when it is recovered.
Where is the original?
They just give me the photostat copy of the same.
Where is the photostat?
That I can place it on record.
Why haven't you placed it? Because this is completely contrary to what they are saying.
That's the account statement your lordships are referring to. That's A2 of.
When did
the
you
appli-
last make payment of the installments?
That's, I can give the dates, Milords.
You are not prepared with your matter. Why
Milords, with
should we
regard
pass
to
any stay order?
Milords, with regard to that aspect, I
No,
can.
we have taken a loan. You have entered into an
Please,
agreement.
Please, lordships.
Agreement to that effect that they have a right of this repossession.
Milords, they
If it
do
is a
not have a
case
right.
that, no, Mr. Counsel. If it is a
Please,
case
Lordship.
that you have made the payment
Please,
and
lordships.
they have then also taken it, then it's a
Please,
different thing. But you have not enclosed the bank details by which it will show that you have made the payment to them.
Milords, their
Payment,
account statement.
are you making payment by cash?
Milords, their account statement is
Mr.
with the
Counsel, are you
lordships.
making payment by cash?
Milords, I am
You
replying
cannot make a
to your
payment
lordship's
of a
query.
loan payment by cash. It has to be only as documented. Why
Milords, I am
haven't you
not.
enclosed any of
Milords,
such documents?
Milords, may I reply to the query, Milords, one by one? Milords, first, Milords, Annexure A2 is a statement dated 4th of September 2025. The payments are never made in cash. The payments are made by way of bank transfer. It is automatically deducted from my account.
So where is
Coming
your
to the
bank
last,
statement? No,
Milords,
Mr. Counsel, where is your bank
Annexure
statement?
A2 is the account statement itself. And Milords, this particular
Annexure?
argument A2, which your lordships referred to,
Where is
is an
A2? We
account.
don't have A2.
Milords,
Annexure
Annexure 2
A2, page 32.
of the writ petition, your lordships, or of the
Page?
application? Milords, page, Milords, I'll just give Milords. Annexure A2, Milords, is a statement, Milords, which reflects. Milords, page 38. Loan account, Milords, and EMI amount is 94,000 rupees. And as per my instructions, the amount
Page
which is due
38
is.
is a different thing. It's a master circular. These have nothing to do. I'm not asking you that. My question is specific. If you have made payment, why the bank statements have not been enclosed, which will show
Milords,
that from your bank account, this amount has been deducted timely. This
Milords,
will
my
show.
submission is. Milords, my submission is not
Not
that
going
I
to
have
pass.
paid the payment and they have recovered it.
No case. I think we
Milords,
just go for dismissal right away.
Milords, my submission before lordships is.
Your petition should
Milords,
be dismissed.
Milords, my
Not
submission
a
before
fit case for
lordships.
issuance of notice.
Milords, may I submit, Milords, exactly
Yes.
what exactly is my submission? Milords, my submission is not that I have paid the payment and they have recovered it. This is not my submission. My submission before lordships is that only 2,87,000 was due when the vehicle was recovered, and notwithstanding the fact that this amount was due, even then the Reserve Bank of India and the Honorable Supreme Court of India mandates that they cannot deploy recovery agents to recover the vehicle, notwithstanding the fact that I did not
The
pay the
finding
payment.
of fact, go before the civil court.
No, Milords, it is not a
Go
finding
to
of
the
fact.
civil court.
It is not a.
See,
It is not a
you
finding
cannot
of
make
fact.
Mr. Counsel, you cannot make an allegation. If we see annexure 2, page 32, it shows that there is a balance outstanding of 19 lakhs as on 4/9/2025. Even this document shows so. Now, we
Milords,
don't know
that is
on
the
what basis
entire
do you
amount.
get this document.
Milords, I will, Milords, I will
You
justify
have
how
not
I get this
enclosed the
document.
photocopy of the document.
Milords, this
This
particular
is a
document.
statement made by you. And the
Milords, it is.
best document would have been your bank statement, which would have shown
Milords,
that this amount has been deducted.
Milords, there are two types of due amount which is there. One is due and the one is overdue. Milords, due amount is the entire loan amount which I have to pay till 2027-28 when the loan matures. That payment, 19 lakh, which your lordships are referring to, is not the one which I have to pay on 4th of September 2025. Till 4th of September, only 2,86,000 rupees was due,
Where
as your
do
lordships
you
have
get
observed.
this particular document?
From the bank.
Where is it? Whose
Milords,
signature
I
it
will.
is? Whose
Milords,
under whose signature have you got this document? If it is a digital
Milords, it is.
document, no, Mr. Counsel, if it is a digital document, you could have very well enclosed it.
Milords, I will annex the digital document. I may be given a time and I'll place it on record.
Issue notice, nothing more.
Please, Lord.
I'm not
Milords,
satisfied.
but alienation at least be stayed.
Nothing.
They will sell the vehicle.
Sorry. You have not produced anything to satisfaction of this.
Millets, I may be allowed to what extent I have to,
I
with
may
regard to
only
what,
allow you to withdraw the writ petition and file it properly if you want. Otherwise,
no,
nothing.
Millets
matters.
may issue notice,
That is
Millets,
the
but
only
Millets, I
allowance
may
which you
be,
can get.
Millets,
No,
I may
sorry.
be informed that to, as
No,
to what
nothing.
aspect I have to satisfy
Notice.
your lordships.
Making it returnable on 6th of March 2026. Mr. J. Hendick accepts notice on behalf of. What is this for? Station house officer? What is
That
this?
is the concern, Millets. It is in our parlance, the in charge of the police station is referred as
Mr. Counsel,
station
you
house
cannot
office.
go as per your parlance. Your parlance may
Please, Your
happen in Delhi, not
Please, Your
here.
Lordship.
Here
Please, Your
we
Lordship.
call it the officer in charge. And the officer in
Please, Your
charge
Lordship.
is the mandate as per the CRPC as well as the BNSS.
Please, Your Lordships.
Appears on behalf. You accept notice for 1 to 4. This is wrongly given. They don't know. 1 to 4. Mr. M. Sharma accepts notice on behalf of the respondent number 5. Extra copies of the writ petition along with the additional affidavit so filed. Then additional affidavit so filed be provided to the learned counsels who represents the respondents by tomorrow. Pustak. The case of the petitioner herein is that the petitioner's vehicle bearing registration number AS01PC 0167, which was financed by the respondent number 5, was repossessed by not following the mandate as per the law. Pustak. Mr. M. Sharma, appearing on behalf of the respondent number 5, submits that the respondent number 5 not only have issued that there is an outstanding amount of rupees 18,64,005.31 as on, what is the date? 16/12/2025. The petitioner's account has also been declared as NPA in view of non-payment, non-servicing of the installments. Apart from that, various notices were also issued for repossession. Pustak. The learned counsel therefore submitted that with the aid of the police officials of
Your Lordship, Bhangagar Thana.
police
Not
official
with the
of which-
aid of them, Millets. It is not with aid of them. They've just informed them. No police official came on the spot.
you
We have
need know.
informed the local Thana police, your Lordship.
Which local thana?
Your Lordship, the only annexure I have obtained today's morning, your Lord.
Very excellent. Which local thana?
Itasali,
Huh?
Itasali town outpost. It's in Nogam district, your Lord.
With the no, prior to that you did not inform.
Your Lordship, that exercise will be taken only before taking of the possession.
No, this is post
Sir,
repossession.
prior to that document to pre-intimation also.
Submitted that on 15/12/2025, the senior inspector, Itasalip town outpost, was informed that steps are being taken to recover the possession of the vehicle. He further submitted that on the same date, that is on 15/12/2025, the senior inspector of Itachali town outpost was also informed that the the possession of the vehicle was taken. Pustak. It is the opinion of this court that the said aspect be brought on record in order to adjudicate as to whether the respondent authorities, more particularly the respondent number 5, while taking repossession of the vehicle, have done so by following the mandate of the mandate as laid down by the Supreme Court in the case of
ICICI Bank versus Prakash Kaur. Your Lordship.
Manager ICICI Bank versus Prakash Kaur, reported in
2007 1 JT. Your Lordship.
what JT?
2000
You don't go
Judgment today, my lords.
By, you don't go by JT business. SCC to side review. SCC so and so. That's the judgment of Justice A.R. Lakshmanan.
My lords, Justice A.R. Lakshmanan and my lords, Justice
SB
Altemis
Sinha.
Kabir. Justice Altemis Kabir, my lords. Justice Altemis Kabir and Justice Lakshmanan were holding
But
the
there
legal.
you are referring to the minor, the conquering, not the main one.
My lords, the concurring view is the common view in the end that we deprecate this practice.
We'll see
That
later
is
on.
a and subsequently, my lords, there is
Enough.
a three.
Instead of saying find out the SCC online citation. Yeah, full stop. The respondents
Your Lordship,
shall
2007
file
to
the-
SCC 711.
Yes, the-
2007 to SCC 711.
so and so. Full stop. Taking
Lord.
into account the above, this court during the course of the inquiry, the hearing inquired with Mr. M. Sharma, the learned counsel, appearing on behalf of the respondent number 5, as to under whose possession the vehicle is. He submitted that the vehicle, the repossessed vehicle, is under their possession, taking into account that the instant dispute is being taken up. That the dispute as regards the legality and validity of the repossession of the vehicle is being taken up by this court. The respondent authorities shall till the next date not dispose or alienate the vehicle. The respondents shall bring on record their stand by filing the affidavit. The respondent number 5 shall bring on record their stand by filing the affidavit. In addition to that, the respondent numbers 1 to 4 are also directed to bring on record as regards the intimation so provided as to whether due intimation was provided prior to taking repossession of the vehicle in question.
Grateful, Lordships.
That shall be to party 9.
This is the instruction Lordship.
Yes.
But will issue notice, I'll put it on affidavit, my lord. It will be placed before the corporation. The mayor and council has reversed the.
There's an order passed by the appellate authority.
Had been appellate authority reversed the order of the commissioner, my lord.
Then?
Then it will be placed before the corporation, my lord.
No, I'm not on that. You have sealed his premises. Very well.
Fine was there.
You have sealed his premises. So it is not a permanent thing.
Not a comment.
You can again seal it.
That can be done, my lord.
If the corporation holds otherwise.
That-
Now on 5/8/2025, the appellate authority held don't seal that sealing is bad. So you have to therefore take action for desealing it. You file an authority case out there before whatever may be or exercise powers under 4838(2). But till you get an order there, you cannot continue with the sealing of here. Are you going to pay compensation to him for the sealing of the vehicle of his property? Give an undertaking that if you lose your case at any point of time, because after the corporation also you're going to pay him the compensation given undertaking.
Not to allow for-
Otherwise, deseal it. By tomorrow, deseal it, let him use it, and thereupon get an order from the corporation and again seal it. Isn't it, Mr. Counsel?
He's-
I hope you have understood what I am saying. What have I said? I have said something in your favor. That have you understood that? Then you should say yes, nothing more than that.
My lord. Lordship will make it clear, my lord, if there is order from the,
Then they will. But you have to act immediately. When there is, because the order happened on 5/8/2025. So therefore, to keep the property of the petitioner under seal, where is the sealing? Whatever you sealed.
this is a business premises.
Shall
that
we
were-
hereby to pay? Huh?
This is a business premises, we say that
Seeing the peruse the ornament and wherein the counter is directly to take a decision within 3 days of the receipt of the petitioner's reply, where it's evident of the representation by remand, execute an agreement with his landowner to carry out his business. So and so has obtained the trade license on so and so. Therefore, under the above provision, director demand so and so, directed to pay penalty of rupees so and so, and so. A written reply before the standing appellate committee. The disposal in view of the whether speaking order is held to be arbitrary and without application. Yeah. Heard Mr. So-and-so, the learned counsel appearing. I am allowing your writ petition. Happy? Chalo. Take your seat. You keep on standing, yes. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. Esbora appears on behalf of the respondent number,
I was
all the
guilty.
respondents. The petitioner herein, who is one of the directors of a company in the name and style of MS Excel Engineers Innovations Private Limited, is aggrieved by the actions on the part of the respondent number 2 to continue with the sealing of the petitioner's premises in spite of the order passed by the appellate authority dated 5/8/2025. Full stop. This court have heard the learned counsels appearing on behalf of the brief facts which led to the filing of the instant writ petition are as herein under are that the petitioner the petitioner's company that the petitioner company had executed an agreement dated 10/5/2024 over the 2 kata of land for open up a branch office at Gauhati. The trade license was obtained on 16/8/2024 from the GMC authorities. It is the further case of the petitioner that the construction of the premises wherein the petitioner would carry out its branch office was yet to be completed when the respondent authorities, more particularly the respondent number 2, had sealed the premises of the petitioner on 9/8/2024. The petitioner thereupon approached this court by filing a writ petition. This court, by an order dated no, yeah, I will file the writ petition. Oh no, full stop. Oh no, writ petition. No. Which was registered and numbered as WPC number 4246/2024. This court, by an order dated 22/8/2024, disposed of the said writ petition, directing the petitioner to apply to submit the reply to the notice dated 12/8/2024 by 1 month, within 1 month from the date of passing of the order, and thereupon the respondent authorities were directed to take a decision within 3 days from the date of receipt of the petitioner's reply. The petitioner accordingly submitted the reply to the notice dated 12/8/2024. The said reply of the petitioner was not considered, and a speaking order was passed on 28/8/2024, imposing a huge penalty of rupees 3,25,000 against the petitioner, and also 25,000, which the petitioner has to pay in order to deseal the petitioner's branch office. The petitioner thereupon filed an appeal before the appellate authority on 6/9/2024. The appeal was registered and numbered as appeal petition numbers GCL/31/2024. However, the appeal was not taken up for disposal. And under such circumstances, the petitioner was again compelled to approach this court by filing another writ petition, which was registered and numbered as WPC number 4198/2025. This court, by an order dated 30/7/2025, directed the appeal committee of the Gauhati Municipal Corporation to dispose of the appeal at the earliest and preferably within 15 days from the date a certified copy of the order was served upon the Commissioner GMC. The materials on record further show that on 5/8/2025, the appeal committee, the appeal was disposed of, thereby holding that the order dated 28/8/2024 was devoid of any reasons Additionally, the respondent number 2 herein was directed to grant a fresh trade license to the petitioner in terms with section 180 bracket 2 of the GMC Act 1971 with effect from 10/5/2024 and further deseal the premises of the petitioner. Full stop. The petitioner thereupon, the respondent number 2, in spite of the said order, did not deseal the premises of the petitioner. The petitioner was compelled to submit a representation in that regard on 22/8/2025. But the respondent number 2 did not take any steps. So it is under such circumstances, the petitioner is compelled to approach this court for the third time by filing the instant writ petition on 16/12/2025. When a matter was taken up by this court on 21/1/2026, this court sought for instructions from the Standing Council of the GMC. Thereby fixing the matter on 6/2/2026. Again, on 6/2/2026, the Standing Council of the GMC sought for time, and accordingly, the matter has been fixed today. Mr. Espora, appearing on behalf of the collector, Gauhati Municipal Corporation, appearing on behalf of the GMC, submitted that an instruction has been received from the collector, Gauhati Municipal Corporation, that the commissioner, GMC, have taken a decision to approach the general body of the corporation for determination under section 438 bracket 2 of the GMC Act. It is also mentioned that pending the resolution and decision of the general body on such reference, the commissioner is not legally bound to implement the decision rendered by the appellate authority. This court duly takes note of section 438 bracket 2 of the GMC Act 1971. And for the sake of convenience, the said provision is reproduced hereunder. From a perusal of the above quoted provision, it would be seen that the commissioner has to refer the matter within 60 days of the date of receipt of the order. And it is only in such circumstances the commissioner shall not be bound to give effect to the decision of the mayor in council. In the instant case, the order dated 5/8/2025 was marked to the respondent number 2. In addition to that, the petitioner have also served the copy of the order on 22/8/2025. The period of 60 days is well over. Under such circumstances, the action on the part of the respondent authorities to continue to keep the petitioner's premises sealed not only violates the mandate of the GMC Act 1971, but also intrudes upon the petitioner's rights under Article 19(1)(g) of the Constitution. And, full stop. Apart from that, there being no reasons assigned, the action on the part of the respondent authorities, more particularly the respondent number 2, is arbitrary and appears to be, and also suffers from malice in law. Full stop. Considering the above, this court therefore disposes of the instant writ petition with the following observations and directions. Full stop. The respondent number 2 shall forthwith comply with the order dated 5/8/2025 passed by the appellate authority. The said compliance should not only be given forthwith upon receipt of a certified copy of the instant order. Full stop. The said compliance shall not be later than 5 days from the date of receipt of the certified copy of the order. In that regard, the respondent number 2 is further directed to file an affidavit of compliance within 15 days before this court for the purpose from the date a certified copy of the present order is served upon the respondent number 2. Next. It is, however, observed that the above directions shall not preclude the respondent number 2 to take action in terms with section 438(2), if so, of the GMC Act, if permissible under law. And if such proceedings are entertained, and the order dated 5/8/2025 passed by the appellate authority is reversed, the respondent number 2 would be at liberty to do the needful. Compliance. What is wrong with your GMC? It seems that you have some malafide action against him. Taking into account that his senior does not appear, you have taken advantage. No, Mr. This is the third time. And I think I have passed one other order also. You see one order. They cannot impose this 5,000 like this. There's another judgment passed by me. I did not refer it today.
4,401 is the new enactment, my lord. 401 is the new enactment, my lord.
Understood. That only I have looked into and passed an order.
Maximum is the 5,000, man. Maximum is the
Maximum is the 5,000.
Pardon.
There cannot be so much what they have done. I passed a judgment. Have a look at it. What is this? Where is the notice?
Some individual notices also served.
So did you submit as per the notice?
Yes, now we submitted, they refused to, because we
They have refused.
heard 1 day prior to this day. Final day.
Huh?
But we will heard this notice.
Let us come to 353. Yes.
Yeah, submitted. We got this notice on 22nd January 2023. 23 July. So we took it next day. They refused. We came before this court, then they accepted. Now it is there.
Have they evicted you? Have they evicted you?
No. Huh?
No instruction required. Yesterday, on last Friday, I passed an order.
Otherwise, we are
Can you
directly
imagine?
covered by Salakuddin.
Not Salakuddin. Salakuddin, I passed a better order than that. Day before yesterday, it was a AR Bhuyan order, Friday. I passed that order to the effect that this notice shall be taken as a show cause notice, giving you 20 days to file a reply. After that, they will pass a speaking order
So here,
and give you another 15 days for taking action.
nice. That was not.
You want that order?
Salakuddin.
Now, Salakuddin says that issuance of notice is required because the point of reference was as to whether notice is essential. But this is a development beyond that to that order. I think we can dispose it off. That day I passed that order in presence of everybody.
I'm not aware.
Keeping these matters pending makes no sense.
Might be.
Because the ball has to move.
Yes.
If I stay this, it will be only delayed. So let them within 20 days submit their representations,
Then,
individual representations. And my direction was to give it to the district commissioner. Where? Boitamari is where? Bongaigaon? Okay, the circular officer Boitamari will be under district commissioner Bongaigaon. And it shall be either decided by the district commissioner Bongaigaon or the co-district commissioner. Is there any co-district commissioner in Bongaigaon?
Bongaigaon, I do not.
Now, whether it will come under, but whether Boitamari will be there. Who is the ADC to the ADCs are now the co-district commissioners. Okay, let us give only to the district commissioner.
Then.
District commissioner is.
You give it to that. So the district commissioner, either he can decide or the co-district commissioner, because this will have a huge exercise because there are a lot of people out here and everybody has to give respective representations. It cannot be you give one like a petition file like this. No. It has to be given by everybody. It order to court. Kali disil na hele. Apne disil na soi korido upload ho na. It. But here it was in Gauhati, and as it was in done by the Posim Boragaon. Posim Boragaon is there, Puk Boragaon something is there. No? So that will fall within the ambit of the co-district commissioner Gauhati or New Gauhati, whatever may be, Gauhati or something. Central Gauhati. The Central Gauhati or the district commissioner. So therefore, he may do it or his co-district commissioner. এই লাষ্টৰ পেজ কেইটা ওলাব নহলে মস্ত ডাঙৰ হ'ব এইবোৰ পিটিশ্যনৰ নামবোৰ চব আহিব চব নামেই আহি আছে চব Now, Mr. Monto, have a look at this. The last paragraph, the various directions passed in the last paragraph. No, last paragraph, these are A, B, C, D, many directions given.
If you have a copy, Ilya Vasu, in 8/1/8/2026.
I think this will help you out. This is in fact, even in reserve forest, recently on 10/2/2026, the Supreme Court passed an order, even in a case of, this is the wasteland. Here, there might be question of whether you are entitled to settlement or not. These are many questions which are there. But even in reserve forest, where there is no question of settlement, there also the Supreme Court directed on the basis of an affidavit filed by the government and to first have a committee. Here we don't require a committee because the district commissioner or the co-district commissioner can look into it. And then say that you giving them some time, 15 days for filing. I gave that in that case 20 days because of the fact that I passed it on Friday and they may not get the certified copy on Friday. But the order was ready and gave it on Friday itself. But anyway, be that as it may, so I gave 20 days. Then the second is, this has to be respective with the affidavit. And thereupon, they will pass a speaking order by giving a personal hearing because you have to give evidence, you have to express this. So therefore, it will be done. Then. So therefore, we dispose it of in terms of this. Dispose of for ribo khali akman agor facts kini agor facts to put us. Agor kini it was kini no. And did you file any application for settlement? No.
Yes. Yes.
You have filed. It was it. You have holding numbers? Do you have houses out there or not? Have you been, are they assessed by the GMC? Okay, so this is rural area. It's okay, to line to nalage, GMC to nalage. At a line, Mr. K.K. Mohanto, the Learned Senior Counsel, submitted that all these notices were received one day prior to the date fixed for vacating, vacation. Baikhini eki kori dibo ha parbu borbujari enike kori Salakuddin sahib le ekon kori dim notice ekon enclose kori disu etu dokar nai aru direction de etu enike okay disposed. Now, Mr. Purkasta, your junior mentions the matter at the mentioning hour to say that Passover. I said, what has happened? Passover at the mentioning hours. So, I thought that Mr. Purkasta would be very busy in some court whole day. Anyways. Okay. Ah, yes.
I told the commission other day was that, both is competent to issue from mandamus. And there is an issue of one is actual of public authority to discharge public duties. There is a certain position of law, I think, not educational or number of issues are there. Once there is a direction, an order was communicated to the circle officer. There is no opinion for this circle officer to sit over the matter.
Huh?
Sit over the matter by not taking out the direction of the deputy.
You were asked to appear before that court. What has happened? The order has been passed whereby, as per the latest Jamabandi, name of Kanika Pathak is found to be the sole patadar of the land covered by so and so. But as per in view of the above, the circle officer is directed to reinstate the name of Sutradhar so and so, India. Then If this order is passed by the Deputy Commissioner, why you are not going before the Board of Revenue?
Favor. In my favor.
Which one?
Also, I am the Krishna Kanto. I am Krishna Kanto.
In view of the above, circular officer is hereby directed to reinstate the name of Krishna Kanta Sutradhar in so and so.
And
Then,
they are not doing anything. I am Krishna Kanto. Krishna Kanto is before your lordship.
then,
Correction was going to make correction by inserting his name. That was not done.
so name has not been inserted.
Correction was done.
Okay, so where have you approached? That is what I asked you to file an application.
A.
Oh, IA is not here. If you had filed an additional affidavit, it's a different way.
Because I need to.
You have filed an IA. No IA. So we have it some other day. Mr. A.K. Purkasthar, the learned counsel, submitted that an interlocutory application has been filed. So stop taking into account the above, the same interlocutory application along with the instant writ petition be listed again on 20, how much time it will take? 27. 27 be listed along with IA number on Wednesday.
1691.
Can we have it on Wednesday? Yes,
Coming.
yes.
Lordship, I will take it,
Okay, no problem.
Friday.
On 27th of February, I'll give you enough time.
Fine.
Item 5.
Cancellation of registration.
Why? Fail to furnish returns. Why didn't you file the file revocation?
Because the time period, it was their minutes, when you found out that the PSF cancelled minutes, has already elapsed minutes.
Why didn't you find out?
We could not find out because at that point of relevant point of time minutes, we were not also having any regular business at that point of time minutes. Then we found out that our GST, on only November 2025, when he entered a new tax consultant, then we found out that our GST already has been cancelled. And then we found out that then we filed a return also.
When did you get the so-called 24?
So cost minutes is
Got the registration in 2022.
Well, wait.
Furnished by you under section E, failure to furnish return. Suspended insurance. Then how did you file your return?
plus that was only till the date of cancellation.
Thereafter?
We could not.
So when did you file last?
Minutes in November, in page number 19 minutes I have
November
2025 minutes.
20?
5.
How could we file? Your registration was cancelled in 2024. How could you file in November?
That's till the date of till it is cancelled minutes.
It was cancelled on 6/11.
We filed up earlier return.
Earlier returns means where?
You should put time period minutes till the time minutes registration was cancelled. Returns for the date prior to cancellation.
What is the date of filing? 1/11/2025. There?
But however, we could not file for the earlier returns after that. So we have to revive this cancellation GST minutes. And we have to furnish all the returns and taxes minutes.
Okay, same order.
But some, my lord, observation, then, my lord, this cannot be a, my lord, regular. Whenever they will require, they will refer to the honorable court, they will revise, then thereafter.
You take penalty.
Lordship.
I've
The
said.
penalty part is there, but, my lord, when there is no business. tax
Then
will be
only,
zero.
then only the lawyers can thrive. You have to think about that. You see, the problem is, when I was taking up the Motleb Ali's judgment,
Yes, man.
I was looking very deep into it and seeing as to whether this court can stop it.
Lordship.
That once you file it, if you don't file it within that period, now there are various provisions of law that if the act does not proceed, says that, okay, within so much time you have to file it. And then an appeal lies. An appeal also no time has been given that he can seek for revocation within 270 days.
Lordship.
Then an appeal lies there against under 107.
Yes.
After the appeal also they cannot, but the appellate cannot condone more than 30 days.
Man.
So all these things are looked into. But at the end of the day, the problem is all the judgments of the Supreme High Courts have been uniform to that effect that it would violate their right under 19(1)(g). So they will be therefore liable for penalty so and so. After looking into this, therefore, because if you remember that matter, I was taking up very seriously on this
Yes, yes.
as to whether it can be. I tried all my best to now. So therefore, it is a fact that you can't help it.
And they cannot be left remediless.
There has to be, therefore I put it, they will be liable for arrears, tax, penalty and all other charges.
Man.
It will registration, cancellation, judgment disposal. Mr. Sharma, what is this? Tender, what is this? I'm bench 4 also.
My lord, it is the PGR, my lord, eviction of PGR, my lord, Roship has passed the order.
Same.
Same, my lord.
Then why is he issuing challenging a tender notice?
My lord, now my lord, tender notice was issued, my lord, which had a vacant land of PGR to fence it, my lord, Clyde Gateway. Yesterday, there was a tripartite discussion with the Chief Minister also. And yesterday also discussion it to council, my lord. Work has not yet started, but instruction has been given to fence out, my lord, those who have vacant land, my lord.
Very good.
Yes,
This is necessary. So same order.
same order, same order.
Okay. Itu Karbi Anglong. Huh? Same order.
Same order.
You have not enclosed.
Not
We are not touching on that ARA, the tender notice. We are not touching. Disposed. Itu Karbi Anglong to. Mr. R.P. Sharma appear for a case. Yes, what is this?
And the authority, in the PWC authority, has given a portion of the plot of land for construction of a foot overbridge across the Great Road.
Requisition? Acquisition or requisition?
No, guess what? Point is here. They initially initiated the process for requisitioning the land behind my back. That is one part of the matter why we are disappointed, why we agree, my lord, without correcting it. And now, my lord, we have come learn from a letter issued by the land acquisition branch addressing it to the office of the executive engineer, PWD, saying that whatever grievances we have been raising, that this footbridge which will be constructed on the plot of land would fall directly on the entrance of the petitioner's house, making it permanently difficult for these petitioners to ingress and egress, my lord. So what we are contemplating, my lord, if the land acquisition process continues, my lord, we have not started the acquisition process, although a land acquisition case has been registered, my lord, what we could learn from that letter, my lord. Now we are on a very limited prayer, my lord. Our contention is that we are not aggrieved by the fact that they have a project to construct a foot overbridge for the convenience of the experience. We're not objecting to that. Only thing we are objecting is that let them find a suitable place, because the amount of land they are taking is old HRs from us. Even that also is not a problem. The problem is that when the footbridge falls, it should fall directly on the entrance of the gate of the petitioner, and making it impossible for them, for them to go and have an access to the main road or to their residence. So this is the basic grievance we have for lordship. And the process that they have initiated for requisition, and take the lordship knows that under section 3(1), before an order is passed, that order has been served on us. After the order of requisition is given, that has to be served on us. And under Rule 11, there is a procedure how the order has to be served to the incumbent concerned mother. Now, they never served any such order of requisition, because had they have passed that order, there was an appellate provision under section 3, wherein we have given an appeal that your location should be reconsidered on the ground that we have these
difficulties. Now, nothing of that kind was done. Ultimately, we came across this communication, which might not be kindly come. I'll take your lordship to this communication square.
Page 80.
Page 80, my lord. On 8th of 10/2025.
Assam Land Acquisition and Requisition Act. If in the opinion of the state or any person authorized in this behalf, it is necessary to do so for maintaining supplies so and so, so and so, so and so, or accompanying so and so. This is the state government or the person. These are what they do. Not use of things and search in the state. Let's see the order.
Come to page 80.
Huh?
80.
80.
This is not put to challenge, but this is a communication from where we have learned number. May I review? With the executive engineers, this from the land acquisition branch.
No. Where is the notice?
This, we have, till that we have not received any notice matters. That is the crux of the matter, madam. This has been sent by basically ventilating my grievances. One assurity, a right-minded person may have forwarded this letter to the executive engineer to examine my cause, madam. May I just submit, madam?
So the footbridge will be here.
Yes, ma'am. I have given the images, photograph, madam.
So therefore, you cannot ingress and egress to your place.
83 have given some images, madam. It will fall right on the entrance of my gate, madam. Annexure 10. And then page 84.
Where they are having this footbridge?
This is madam in between the new flyovers they have built, madam. Bogoroto 1, Bogoroto 2 in GSO here downtown, madam.
Ah,
My residence is opposite to downtown hospital, madam. And
Okay.
they are going to construct in between the two new flyovers they have constructed for the pedestrian to cross, madam. Because there is indeed a difficulty for the pedestrian, madam, because they are crossing the road and there's no way that we are not objecting to that, madam. Now this bridge will start from downtown side and it will drop at my residence, madam, basically.
then
Right. Madam, he will start the construction from the downtown side and then it will fall on the other end in the front of my land number 4.
so now you want that, let them do whatever they lay.
Yes.
But while doing so, your ingress and egress should not be, yeah. Whose matter is this? Monmouth people.
There was a title dispute between the family members of these petitioners, and it was settled on the same plot of land by a memorandum of settlement. That also I have annexed. And these parties have mutually settled the dispute and have come to terms wherein they have divided their respective shares. At page 48 is the part of the equity part, but in this books.
So they have their requisitions.
They have, as part this order, my lord, I'll just read the relevant line, my lord, paragraph, my lord.
Where?
At page 80, the second, I'll just read a short letter, my lord. With reference to the subject cited above, I would like to send herewith a copy of the petition mentioned above received from Monumoti Purva, my lord, the petitioner and 20 pensioners, 14/8/2025, pertaining to acquisition of land for construction of footbridge between Bogoroto 1, Bogoroto 2, and GS Road, contents of which are self-explanatory. it is pertinent to mention that land measuring 4 hectares covered under tag number 1066 and photo number 131 of Village has already been requisitioned, my lord. This is my grievance without giving any such orders. Under section 3.8 or 3.1 of the Assam Acquisition Act 1964 by LA case number 27 of 2025, my lord, on the basis of land acquisition proposal submitted by.
Okay, then what happened? This happened on 8/10, then?
Then, my lord, I was expecting that on the basis of my petition, that is 14/2025, and then they have basically said.
So
that-
what they have done now?
Well, they were supposed to call me and, my lord, take a hearing on whatever, my lord, problems I'm having, my lord, because it says that they need to examine my matter. Till that they have not done anything.
Then,
But only difficulty is my tomorrow, without giving me a hearing, if they start construction work. And
elections are coming. Nothing is going to happen.
Hello.
I think the plate of the state is full. Huh?
Hello.
The chief minister now doesn't have the time for inauguration of laying foundation. He's too busy in other places. What do you say?
Yes, my lord.
Isn't it? Therefore, nothing is going to happen.
is it just that?
Have you considered it? You do one thing, we issue notice and inform us as to have you taken into consideration what steps are being taken in pursuance to that
Our consideration of our grievance.
their representation they have submitted. Okay,
They have till then some protection. They may not
what
take it.
protection? Nothing is going to happen. Don't worry.
Some kind of observation. I will-
Don't worry. Issue notice making it returnable on today, 23rd of February 2026. Miss,
That description process which they have undertaken. Them keeping again that is unique them. Because the question is not that I'm not objecting that they should not take my land, but the way they are starting to do the project, like if they have to take my land, that it will be it will not be a fruitful exercise for people of the party, but at least for us. Because if the land is taken and we just brought in the same place, we are not going to gain anything.
Mr. Buragai, I'm fixing it on 23rd. That is why. Let us know what has happened because that happened on 8/10. And 4 months, nothing has happened to you. So nothing is going to happen by next week.
There has been some process undertaken in the office of the special officer.
So therefore you know something.
No, I don't know. Of course, these are all heard, hearsay.
Let us issue notice making it returnable. Diane Goswami accepts notice on behalf of respondent number 1,
5, 8, 9, and 10 lots.
8, 9, and 10. Mr. So-and-so accepts notice on behalf of the respondent number 2,
3, 4, and 5.
4, 5. And Ms. So-and-so accepts notice on behalf of the respondent number 6 and 7. Extra copies of the petition be furnished to them by tomorrow. The case of the petitioner herein is that an area measuring 4 acres of land belonging to the petitioner have been requisitioned under the Assam Land Requisition and Acquisition Act 1964 without following the mandate in terms of section 3 of the said Act of 1964. Mr. H. Burago and the learned counsel appearing on behalf of the petitioner drawing the attention of this court to the various photographs enclosed to the petition submitted. That from what the petitioner could come to learn from reliable sources is that the landing of the bridge which is being proposed to be constructed over the footbridge which is proposed to be constructed would fall in the entrance of the petitioner's land and thereby make it impossible for the petitioner for ingress and egress to her own land. The Learned Counsel further submitted that in that regard, a representation has been submitted by the petitioner on
It says 5/8 and 14/8.
14/8/2025. And in that regard, the subdivisional officers, HODOR, have also written to the executive engineer PWDR by the communication dated 8/10/2025 to take into consideration the said representation before initiating any proposal. The Learned Counsel further submits that in recent times, there has been a move to take over this, to proceed with the land acquisition proceedings. And that too, which is in complete violation to Section 3(3) of the Act of 1964. The Learned Counsel therefore submitted that this is a fit case wherein certain interim directions are to be passed so that the petitioner's ingress and egress to their or her, to their premises, their premises is not disturbed. Mr. B. Chaudhary, who appears on behalf of the PWD, and Mr. N. Goswami, who appears on behalf of the district administration, shall obtain instructions and place it before this court as regards the status of the land acquisition case, being LA case number. So and so. What?
82nd paragraph.
LA case number
27.
27/2025. And as to whether the petitioner land would be ingress and egress would be affected if there is a construction of the footbridge. The Learned Counsel appearing on behalf of the PWD shall also apprise as to what decision has been taken by the respondent number 5 in pursuance to the communication dated 8/10/2025 issued by respondent number 10. List accordingly.
Not factual metrics involved in the present list, my lord. Therefore, the authorities my lord, thought it proper and prudent, my lord, to issue this notice. It is a notice simply, sitter, my lord.
So you have issued a notice to him, he will do whatever it is. That's a different thing. The fact that he said that you look here, on one hand, we have filed an application for allotment of these land because of these lands were given to us by those persons who were actually in possession. And therefore, these lands were given to us. But now we therefore sought for an allotment and it is pending. That is one. But what has happened out here is the revenue officer, on the basis of a field verification being carried out by the officer in charge of Bukakhat police station, is trying to throw me out.
Look, that is there, but in the affidavit lordship will find even the SDLSC minutes of meeting. My lord, I am not speaking of that additional 6 bigha. That 22 bigha was not approved by the district commissioner. SDLSC meeting, the district commissioner is the chairperson. Naturally, the district commissioner was not there. Chairperson was some other person. And they hurriedly, my lord, gave it away. That 22 bighas. Now, we are not on 22 bighas. We are on additional 6 bighas.
So therefore, you see, there are, if I am not wrong, for the purpose of deciding an allotment application, as per your land policy, is to be done by the DLSA, District Land Advisory Board,
Yes.
and then it will go to the State Land Advisory Board.
Now it will not come to the district commissioner has been given the authority.
How?
Well, there are some notification, well, I will
In
have-
this case only.
Not in this case. That
No,
I
no,
will-
the district commissioner has been given the authority to allot the land.
Yes,
That's a different thing.
yeah.
But to take a decision is to be done by the district level, the advisory board.
Yes, district level,
So
that is the
this-
primary.
why the district level advisory board is not taking a decision on the 6 because rather it is being taken by the district commissioner?
That is true, my lord, but that.
No, therefore.
Perhaps,
is it-
my lord, that committee
but
is not sitting.
Mr. Borpuzar, the thing is like this, isn't it a different type of action is being sought to be taken against this petitioner herein?
No, it is not, the record doesn't.
It
reflect.
appears. Now, are you therefore saying that for the purpose of land allotment, only the district commissioner can do?
No, then at the end of the day, ratification has to be by the government. So far as.
Forget
my
about
lord,
the government.
The allotment.
We
No,
are not
allotment is
concerned with the
always
government.
commission.
No. You don't need a ratification from the government. If it is in rural areas, it is less
Yes,
than a
that's
particular.
what I was
So
telling
here
you.
you don't require.
Yeah.
Allotment is to be given by the district commission. There is no quarrel with that.
Yes,
But isn't it the allotment process looked into by the district? By the district land advisory board?
yes, district.
Then why it
allotment-
is not being done? But in this case, the district commissioner is looking it. You are giving a personal hearing. So therefore, why not to everybody?
Because it is sub judice, my.
This does not show Mr. Borpuzar in good light of the government.
No, but this matter is sub judice, my lord, and contentious matter, therefore.
So what? If it is contentious out there, nobody has stopped you.
There is a order.
No,
passed by the
nobody
Supreme
has
Court.
anybody stopped you not to decide the allotment application.
No,
Then why you not looking it?
now,
Why should this court look into this type of application? Because the moment we say this, put it in my order, it becomes that, okay, here it can be done like this also. This is not the policy of the government.
otherwise, my lord, so far as the challenge made here to in the present lease is concerned, it is only confined to that notice. That's
So
what-
therefore, we set aside the notice, do whatever you feel like. You know what you can do. But you see, the thing is that you cannot, yes, why should we involve the 6 kathas of land, 6 bighas of land here? Yes, if the action is being taken on the basis of a document prepared by the officer in charge, very difficult. Mr. Day, what do you have to say?
Survey was by the officer in charge, proceedings that can you were not given any opportunity of hearing for,
For?
put forward a claim structure.
That is a different aspect. To forward your claim, that law will take its own course or not. Why? But this notice, can it exist?
This is a separate proceedings that they are.
That is a separate proceeding. So why should we go into that allotment business?
And if for a moment, Lord, see, my lord, page 43. my lord, it's a communication, my lord, from the SDC Bokakhat, my lord, to the government, revenue department.
Or we can do one thing.
Lease is confined only to that notice, per se eviction simpliciter. Lease is confined only to eviction simpliciter. That
We can do one thing. We set aside this notice, giving you liberty to issue notice and proceed as per that judgment that day I passed.
Salahuddin.
No, that recent one.
Yes.
That seems to be proper. Without going into this allotment. I'm not, because this allotment is another thing.
No,
What you have
this is-
done, Mr.
this is
Mr.
not
Borpuzar,
garment to the present
Mr.
stage, yes.
Borpuzar, I'm telling you,
Yes.
what the district commissioner has done doesn't show it in good light. Because he is opening a Pandora's box by this. If I hold anything as regards this, in fact, you should also advise, because it will be for him a separate type of treatment. Why?
No, absolutely, yes.
So let us not take notice
Yes,
of this
yes.
aspect. Whatever you do.
Yes.
We go as per this, because he is in fact, the fact that he is in occupation of government land is not in doubt. But his case is that this
Admitted
land
possession.
was given by those persons who were remaining in the government land for ages and they handed it over. And thereupon he was carrying on and it is essential. So he filed an application. That application is pending. That is
Yes.
what his case is.
Very true, my lord.
Yes. So therefore, once that application is pending, you take a decision on the application because the application, if it is pending from 2018 and today, 2026, it doesn't look nice. Or should I say that, okay, in view of this, but this I don't want to enter it.
No.
Because the problem that I do it, because here if I do it, I will be admitting or
Actually,
becoming
Lordship is correct. If
a
Lordship
part of your design to bring the district commissioner within the fold of land and law.
Now, if Lordship may be pleased to dispose of the present writ application in terms of, my lord, this, of course, this latest decision has come. But Salakuddin still hold the bill because Salakuddin deals entirely with the eviction.
Understood. So therefore, I'm not asking you not to do that. Go ahead. You see what has happened. Because of this, this type of notice being issued, if you have not mentioned these, you have only had the 5-6 lines down below. It's a different thing.
Yes.
But because of what you have done, he has been able to be successful in
Yes,
keeping
yes,
the
yes.
matter pending for the last 8 years. Isn't
but-
it?
Yes.
So why should we stall it? You want to do, but do it as per law.
Yes.
That's all.
Absolutely. Absolutely. But the admitted position is, you know, that they are encroaching upon government land. That is the admitted position.
Huh.
And we need to
See,
take a call.
they are encroaching upon the government land. The fact that they are in possession of government land, I won't say encroaching, they are in possession of government land is not in dispute. Because it is your own case that you have applied for settlement. That settlement has not, application has not yet been disposed of. That is another aspect of the matter. Shall let me come back at 2 and dictate.
My lord.
Sawadan nahi jana. Yes, Mr. Tara.
My lord, this is a classic case of approbate and reprobate, where the respondent authorities having explicitly granted a no objection certificate permitting the petitioner to apply for and secure a post of registrar in Arunachal Pradesh State Human Rights Commissions have now arbitrarily slammed the door such on his release, citing a vague reasons of paucity of officers. A ground, my lord, I understand, is legally untenable, factually contradictory, my lord, to their own prior approval, and effectively nullifies the petitioner's legitimate expectation, my lord, and career prorogations in violation of Article 14 and 16 of the Constitution, my lord. So, my lord, the fact is that on 19/4, my lord, 19/9/2024, at page 25 to 27, my lord, the State Human Rights Commission issues advertise inviting application for appointment to the post of registrar. Then, my lord, on 7/11/2024, at page 24, my lord, the petitioner applied through the proper channel, my lord. Then the forwarding letter addressed to the Registrar General, Gauhati High Court was sent, my lord. Then, my lord, kindly come page 29, my lord. 29 and 30, my lord. And no objection certificate was granted by the Registrar General, my lord. Now, my lord, again, page 31, my lord. If my lord permits, may I read, my lord, this page 31.
Now, what is your prayer? What is your case out here, Mr. Tara?
My case is, my lord, pursuant to the advertisement dated 19/9/2024, I was appointed as the registrar of Arunachal Pradesh State Human Rights Commission. Now, NOC was issued by the Registrar General Gauhati High Court, enabling me to apply
Where is
for
the
the
NOC?
post. NOC, my lord, will find at page 29. Lord.
This is not by the Registrar General, it is by the Registrar subject to compliance by the committee.
Yes,
Then,
page 30, my lord.
page 29, I've looked into it.
29 and 30, my lord.
30 is
30,
different.
my lord.
29 says, subject to ratification by the Honorable Administrative Committee at the time of his release upon his selection to the same.
I bought up.
Then,
my lord, thereafter, my lord, the committee, the Registrar General communicates to the Registrar Itanagar Permanent Bench, saying that you cannot be released because there is a paucity of an officer.
okay.
Then in the meantime, my lord, we see,
26.
yes, my lord will kindly come to page 34 for a moment.
Page?
34, 34, NHS 6.
Yes.
This is my
This is
appointment.
his appointment.
This is my appointment.
Then,
Thereafter, what will happen? I have sent this letter on 9/5/2025 to the registrar to release me from the establishment of Itanagar Permanent Bench.
then,
Thereafter, my lord, thereafter, my lord, page 44, page 43, my lord.
yes.
Type of, see, 44, my lord, the type of. Prayer for release from registry of Itanagar Permanent Bench submitted by Taking Talom. Refer your letter so and so. Sir, in inviting reference to your letter dated 9/5/2025 on the subject cited above, I am directed to inform you that the prayer for release from the registry of Itanagar Permanent Bench submitted by Sri Taking Talam, Deputy Registrar, on his appointment as Registrar Arunachal Pradesh State Human Rights Commission Itanagar on deputation basis was placed before the competent authority. And it was resolved that the Arunachal Pradesh State Human Rights Commission is not operational at present due to non-appointment of the chairman as well as the members. Therefore, you are requested to seek the information from the government of Arunachal Pradesh in this regard and furnish the same to the Now, the status report thereafter was communicated, my lord. Status report, my lord. The status report is at page 45, my lord. The commission was already in function, my lord. Honorable Mrs. Justice Indrasa was a chairperson and one bar. Then another gentleman was appointed, he resigned, and thereafter again, one more member was appointed, Sri Bamang Tago. Now, Sri Bamang Tago, after Honorable Mrs. Justice Indrasa demitted the offer, then thereafter there is no recruitment, and then Sri Bamang Tago has been authorized to function as allowed to look after the office of the chairperson, Milos.
So it was rejected as far back as on 1st of September 2025.
Pardon, Milos.
Page 56. It has been rejected as far back as on 1st of September 2025.
That is what I have imputed.
Yes. Now what has happened?
Yes. Now thereafter, pursuant to these communications, Milos, then the re-advertisement was issued, Milos. Malad will find that page 58.
Yes.
And my description is at Everman is at para 18, page 14 of the petition.
Yes.
Now, thereafter, my lord, although the process has been initiated, but no recruitment has been done. And to that aspect, my lord, I have made a categorical statement in paragraph 29 of my read petition, my lord.
So your thing is, you want this
My
court
lord.
to exercise the powers of judicial review on the
Correct.
question on the satisfaction of the Gauhati High Court on the administrative side as regards why the petitioner should not be allowed to go on deputation.
Correct, my lord.
That's it. Okay, we should notice. Let us see what happens.
And my lord, in view of my averment made in paragraph 29 of my read petition, my lord, that although the advertisement has re-advertisement has been issued, so far no recruitment has been made, my lord. To that re-advertisement may kindly be stated, my lord.
Absolutely no. Advertisement was issued as far back as on 14/11/2025. You have approached this.
I appreciate, my lord. I appreciate and bow down what is falling from my lord. My lord, kindly see, it is
We'll
a
see,
question of
Mr. Tara, the order which you are impugning is dated 1st of September 2025. 5 months have elapsed.
I correct.
So therefore, as on date, we cannot pass a stay order without inquiring as to why it is so. So let them come up and place before this court as to what it is.
My lord, kindly see the predicament of the petitioner. Because
There's no predicament.
authorities-
You are still working. You get your salary
work-
properly. Are you not getting your salary?
My lord, kindly have a look from the doctrine of promissory estoppel. Once you have given me the NOC, then my appointment is there, and thereafter you
There's no NOC given.
reprove it.
There's no
You
NOC
have denied
given
my
because the
NOC again.
question
You
of
cannot be
NOC being
released.
given at page. This was a
29.
big problem which was done because of this. One of your district judges doing the same earlier, giving it to the Arunachal Pradesh Human Rights Commission, and this resulted in me passing an order in that case that unless it is not done by the High Court, it cannot be given. Now he has no authority to give that. In fact, what he has given is also subject to ratification by the Administrative Committee. Now, in pursuance to the notification dated 16th of May 2025, enclosed as Annexure 8 to the writ petition, at serial number 26, it has to be only done by the principal court seat.
But my lord, I respectfully bow down what
Let
is
us
falling
issue
from my
notice.
lord.
Issue
Lord, kindly
notice
see.
making it returnable on. I know person from the High Court.
I'm appearing, my lord.
You are there in the Arunachal. Arunachal High Court, Itanagar bench can't help it because this is the action being taken by the principal seat.
Yes, my lord.
And the principal seat here is not present in spite of the fact that the matter is being taken up in the principal seat. Issue notice making it returnable on 5th of March 2026.
My lord, 5th of March is which date?
Is it Thursday?
My lord, kindly make it Friday, my lord. So that
Absolutely
in
no.
way I can.
These matters, all High Court matters are always taken up on Thursday.
Fine. My lord,
You don't have any urgency, then we can have it on 12th of March
No,
or 19th of March or 26th of March. But
fine,
this
my lord, on
delay is only going to affect you.
my lord, may I just make a small request?
On 5th of March?
My lord, only kindly a small observation. In view of the statement made in paragraph 29 of my petition that although the re-advertisement has been issued, no formal appointment has been made. Anything done thereafter shall be subject to outcome of the petition. My lord, that my lord can consider at this moment.
That I cannot do so because I don't find the Arunachal Public Service Commission,
Human Rights Commission.
Human Rights Commission, State Human Rights Commission. Why the Arunachal Pradesh Human Rights Commission is not a party?
Yeah, me.
How?
Lordship, if Lordship see the respondent number 1, Lordship, there is some technical defect in the
This is not how you make.
The state of Arunachal Pradesh,
This
represented
is
by
the
the
sa-
Secretary
see,
of the State
that
Women
state of
Rights
affairs,
Commission.
Mr.
Lordship.
Tara. The state of Arunachal Pradesh is being represented by the Arunachal Pradesh Human Rights Commission, meaning
How
thereby that what will happen to human rights if the state is to be represented by the Human Rights Commission?
Well,
Isn't
madam,
it the most
I,
funniest thing which can happen?
madam, without any hesitation, I have to accept the mistake that I have overlooked.
You should have
I-
made the Human
I
Rights
cannot
Commission a
blame
party. It is a statutory commission in the main
understand. I
terms of the
understand.
Human Rights that Act. Done.
Madam, I understand. I'll correct the cost item.
You cannot correct the cause title like this. That means you, as of now, Human Rights Commission is not a party. Neither the state of Arunachal is made a party.
Madam,
Because the
in the
state of
meantime,
Arunachal Pradesh has to be represented by somebody.
Close.
the moment, kindly give me a liberty to file.
That would be better.
That
You
will be the
better
best
withdraw
course
and
for
file a
us.
fresh one.
Correct, sir. I'll
You better withdraw and file a fresh one. We'll take
I'll
it
do
up.
that. I'll do that.
Because the
I'll do that.
state of Arunachal Pradesh has to be made with the chief secretary as a party.
Correct,
Represented by the chief secretary. Arunachal Pradesh Human Rights Commission has to be made by the secretary.
Secretary, sir. But there's a
Secretary
small
of the
mistake in
Assam
the
Human Rights Commission, of the Arunachal Pradesh Human Rights Commission.
Well,
So we
Well,
close
well-
this as withdrawn with liberty to refile by removing these formal defects. Because
I appreciate to err is human, so I must have committed a mistake. Kindly allow
what do
me
you want to do?
rectify. I want to withdraw it with the liberty to
Withdraw,
file
yeah.
correspondence.
Mr. Titi Tara, the learned counsel appearing on behalf of the petitioner, submitted that there are certain formal defects in the instant petition, inasmuch as the state of Arunachal Pradesh had not been arrayed in a proper manner. He further submits that the Arunachal Pradesh State Human Rights Commission has also to be made parties separately. He therefore accordingly, in that view of the matter, the learned counsel appearing on behalf of the petitioner submits that he may be permitted to withdraw the instant writ petition and refile by removing these formal defects. Taking into account the above, the writ petition therefore stands closed on withdrawal with liberty given to the petitioner to refile by removing the formal defects. Miss So-and-so appears on behalf of the Gauhati High Court, Itanagar Bench, and Mr. So-and-so Estapin.
Close.
Who is the
Somebody,
respondent number one?
One Lordship. One is mixed.
So-and-so appears for the Gauhati High Court, Itanagar Bench.
अच्छा चेक करना था ना तो कैसे ऐसा करना अब चला गया था
Heard Mr. S.S.D., the learned counsel appearing on behalf of the petitioner, Mr. Arbor Pujari,
And here I am appearing for all the respondents.
appears on behalf of all the respondents. The present petition has been filed by the petitioner challenging the notice dated 5/7/2018 bearing number BKC 41 B.K.C.41/2013/1093 issued by the respondent number 4. Pustak. The brief facts of the instant case, as would be apparent from a perusal of the materials on record, is that the petitioner herein is a cooperative society who is operating the Kaziranga National Orchid and Biodiversity Park. The said Orchid Park, listen, hereinafter referred to as the Orchid Park. The said Orchid Park is spread across an area of 28 bighas, 1 katha, 18 lechas of land at Durgapur village. Full stop. Initially, when the Orchid Park was established, an area of land at measuring 22 bighas, 2 katha, 10 lechas, covered by Dag number 171, 398, 1/175, 232, 233, 283 of the Halwa NC Gao under Kaziranga Moja was allotted to the petitioner society. Full stop. It is the further case of the petitioner that, taking into account the agenda, taking into account that the petitioner seeks to conserve and preserve the rich culture and tradition of the indigenous people of Assam, the local inhabitants of Halua and Sigao under Kaziranga Moja handed over additionally 6 bighas, 1 katha, 12 lechas of land bearing Dag number 398 and 176 to the 76. And the petitioner thereupon have spread its park in a total area of 28 bighas, 1 katha, 18 lechas. Taking into account that the land in question, that is 6 bighas, 1 katha, 12 lechas of land, standing covered by Dag number 398 and 176 of Halwa and Sigao under Kaziranga Moza, was a government land. The petitioner sought for allotment of the said land so that the entire 28 bighas, 1 katha, 18 lechas, wherein the petitioner's Orchid Park is spread on, is being regularized. In that regard, the petitioner had submitted an application on 22/5/2018, which the petitioner claims that the said is pending. Be that as it may, to the shock and surprise of the petitioner, the petitioner was served with a notice dated 5/7/2018, issued by the respondent number 4, whereby the petitioner was asked to vacate the plot of land within 7 days, failing which the petitioner would be evicted from the said plot of land as per law. The petitioner accordingly challenged the said notice dated 5/7/2018 by filing the instant writ petition on 10/7/2018 on 9/7/2018. The record reveals that this court, by the detailed order dated 11/7/2018, issued notice and further stayed the impugned notice dated 5/7/2018 until further orders. The records reveal that the petitioner, the respondent number 2, had filed an affidavit in opposition on 27/7/2020. And the petitioner had also filed a reply thereagainst on 18/8/2025. The question which arises before this court, therefore, in the present facts, is as to whether the notice dated 5/7/2018 can be sustained in law. Full stop. The impugned notice dated 5/7/2018 is in vernacular, and the same have been translated. Full stop. Both the parties herein agree that the translations so made is in order. Accordingly, the said translated notice dated impugned translated notice dated 5/7/2018 is reproduced herein under. A perusal of the above quoted notice, page 48 of the above. A perusal of the above quoted notice would show that the action for evicting the petitioner is being sought to be done on the basis of a field verification conducted by the officer in charge of Bukakhat police station. This court is shocked as well as surprised at the notice being issued by the respondent number 4, who is a revenue officer, inasmuch as it is only the revenue authority who could have come to a finding after carrying out necessary verification as to whether the petitioner is in encroachment of any further land, is in encroachment of any land beyond the land which had been allotted. The notice under no circumstances could have been issued based upon a field officer carried out by a field verification carried out by a police officer. Under such circumstances, the very edifice on which the notice stands cannot be sustained in law. Full stop. Mr. Estate, the learned counsel appearing on behalf of the petitioner, had submitted that in view of the judgment of the learned division bench of this court in the case of Salakuddin, Mohammad Salakuddin versus so-and-so reported in so-and-so, the petitioner is entitled to a notice. In addition to that, the learned counsel also submitted that when notice is to be issued, the notice has to be a reasonable notice, thereby providing an opportunity to the petitioner to place the necessary materials on the basis of which the petitioner can claim that the petitioner is entitled to the allotment of the land in question in view of the land policy of Assam 2019, as well as in view of the extent land policy of Assam from 2019, as well as that the land has also, as well as that the petitioner has, the possession of the petitioner as well as its predecessor have matured in the meantime. First, this court had given an anxious consideration to the respective submissions and is of the opinion that the petitioner is required to be evicted by the respondent authorities, that same has to be done on the basis of a land verification, on the basis of a verification to be conducted by a revenue officer, and not on the basis of a report being submitted by the police officer. In addition to that, this court is further of the opinion that in the circumstance any steps are required to be taken by way of for the purpose of eviction of the petitioner, the same should comply with the mandate of Article 21 of the Constitution. In this regard, this court finds it very pertinent to take note of a recent order being passed by this court in the case of Shyamal Bora, isn't it? No, not this. In the full name to be first name to some. In the case of so and so versus so and so, versus so and so, an order judgment dated finds it relevant to take note of the judgment passed by this court on 13/2/2026 in, you got it? See the first name.
Abul Ali,
Abul Ali versus so and so.
WPC 818 of 2026.
In WPC number so and so. And it is the opinion of this court that the petitioner should be given as in the opinion of this court that the petitioner is also entitled to similar directions. Next. Accordingly, the instant writ petition stands disposed of with the following observations and directions. The notice dated 5/7/2018 impugned in the instant proceedings is set aside and quashed. Number 2. In the circumstance, the respondent herein is of the opinion that steps as for eviction are required to be taken as against the petitioner. A notice has to be issued to the petitioner, thereby affording to an opportunity to show cause to the petitioner. Next, this court further observes and directs that the said opportunity, so to be given in the notice, has to be a period of 15 days from the date of receipt of the said notice. The petitioner thereupon would be at liberty to file its reply/representation claiming why the petitioner should be allowed to remain in occupation of the said land at measuring 6 bighas 1 kata 12 lechas, covered by dag number 171 and 398 of village Halua NC village under Moja Kaziranga in the district of Golaghat, Assam. Next. This court further directs that if the petitioner submits the representation along with necessary evidence supporting its case within the period of 15 days from the date of receipt of such notice, the district commissioner Golaghat or the co-district commissioner shall decide the reply/representation so submitted by taking into account the provisions of the Assam Land and Revenue Regulation 1886 the settlement rules, as well as the Assam Land Policy 2019. First. Next. This court further is of the opinion that as this court had granted liberty to the petitioner for the purpose of providing for educing evidence, the petitioner should be granted a personal hearing so that he can explain the evidence. It can explain. Next. This court further observes that on the basis of the above, the respondent authorities, more particularly on the basis of the above, the district commissioner or the co-district commissioner, as the case may be, shall decide on the reply/representation so submitted by the petitioner, and thereupon pass a speaking order. Next. It is further observed and directed that in the circumstance the speaking order is not in favor of the petitioner, a further 15 days time may be given to the petitioner so that the petitioner, 15 days time may be given to the petitioner so that the petitioner would have the liberty to resort to such legal permissible actions as permitted under law. Next. It shall be within the authority of the district commissioner or the co-district commissioner deciding the said application, said representation, to fix a date for passing of the order on the date of personal hearing or such date as per its convenience. Before parting with the record, this court finds it very pertinent to observe that this court have not decided on the application seeking allotment by the petitioner, which shall be a separate cause of action, which is a separate cause of action. And the respondents herein, this court hopes and believes that the respondents herein shall also decide the same as per the land policy 2008-19.
It can be decided while disposing of their.
Why? No, this is by the land there. Don't do it. You see, if you are doing it, if I do this, it will have far-reaching
No, my lord.
consequences.
My lord, only one aspect, my lord, the notice to be issued, my lord, the authority who is going to issue that notice. If lordship makes some clarification, my lord.
Who will issue notice? Let the district commissioner issue the
Let
notice.
the district,
We'll
commissioner,
put it.
only to that extent, my lord.
The district commissioner or the co-district commissioner.
For district commissioner.
And the representation will be submitted to the authority who has issued the notice.
Yes. I'm so obliged.
What is this?
According to your lordship's last order of 7-1, we have filed the additional affidavit. Facing
I will not file any affidavit, lordship. I will not file any affidavit.
Here for the mother?
Mother. Yes.
Mother has no business.
it comes to the issue affidavit, page 57 onwards.
What did I ask you?
It was an earlier round of litigation.
Petitioner is Imran Hussain Kandakar. Why did I fix this matter?
Lord, what had happened in this case was that there was an issue with whether the first wife was divorced or not.
That is clear. You are the second wife.
Second. And
There's no quarrel with that. The first wife was divorced on the basis of a decree passed by the court.
decree passed by the court and to allow the-
And the second wife, the mother says, is divorced on the basis of a qazi.
Yes,
I remember that.
just one.
Why did I not I didn't dispose of, I also know, because of the fact that he was not represented by his senior.
Yes, Lord.
That day, therefore, I gave him time.
Yes.
Because he sought for time. But now he is not going to get any more further time, taking into account that his senior is there or not there. I gave him the opportunity. Now, the question is, mother, I asked you to do something.
Yes, actually what has happened is that in the additional affidavit, I have placed the copy of the dishonorable court when the husband had approached this court for release of his pensionary benefits, because the first wife has submitted a complaint at that point of time that there is a maintenance case going on between the parties, between the first wife and the deceased. And so his pensionary benefits were stopped. Consequently, he approached this honorable court and this honorable court recorded the fact that there was a divorce under the Muslim law, and thereafter, this honorable court issued a direction that the pensionary benefits should be released.
The only thing which led to withheld the monthly pension of the benefit appears to be the pendency of so and so, but the said case has already been closed as seen from the order reproduced herein above. Therefore, there is nothing to stop the respondents from releasing the monthly and year of the petition. Okay. Hello. And where are the other people? Other councils? Miss M. Bhattacharjee, any government council who can take it up?
No.
Accountant General? Commandant 22nd Battalion? Commandant 22nd Battalion will be Mr. S.S. Roy. Where is he? Has their names been shown? Why their none has appeared? It's because of it's a bench 3 matter.
Yeah, went to the other bench expressed that since Lordship had.
Because at that point of time, I was taking bench 3. But when I took up the matter, you were nowhere to be seen on that date.
No, this matter, before my Lord Justice Mazumdar on that day, my Lord had expressed a view that since your Lordship had heard the matter, so it should be taken up. Lord, we in fact asked, my Lord, that perhaps a date can be fixed. His Lordship expressed inability and said that you can take it up with the race.
No, the order was passed to fixing it on that date. Then none were, and it was taken up in a production list. So none is there. So how do I pass the order in absence of all these people? Aji ki tarikh? Okay. Today, when the matter is being taken up, neither the counsel for the state respondent, the counsels for the state respondents, the accountant general, as well as the commandant, 22nd Battalion, 22nd Assam Police Battalion are present. Considering the above, list this matter again on 19th at 2 p.m. The registry shall show the name of Miss M. Bhattacharjee, learned additional senior government advocate, Mr. C. Borua. Whom do you want as the opposition for Accountant General? C. Borua or Mr. R.K. Talukdar?
Grievance against the Accountant General specifically. My grievance was mainly against them.
Mr. R.K. Talukdar, SC Accountant General, and Mr. S.S. Roy, learned CGC.
I'll inform them.
Inform them. Huh?
Okay.
1947, 2 p.m.
M.K. Brown.
Number 4. I'm for respond number 4.
Now tell me, why have you transferred her or him when he has only 8 months left at the dictation of the minister? Why?
Lordship, we have also received the instructions based on that there was a public complaint petition that has already been filed. Lordship, may I peruse this?
So if it is based on, so I am saying that it is a punitive. I think we'll interfere with this order.
In that case, Lordship, can this matter be taken after some time? Because
Why?
maybe in council is on legs in court number 6, Lordship.
Will interfere with this order, taking into account why, you see, it is if the authorities do not protect you, yes, if there is something illegal, do it. Transfer him, throw him out. There's no quarrel with that. But a section of the people from social leadership have pressurized for his deployment. Can that be a ground? On the basis of the public petition and conversation with the local public, the decision was taken on temporary basis and requested to join at so and so for the smooth functioning of the health institution. Can be reverted if needed. Now exercise your public service and revert him back. 8 months he has. He's going to retire. Almost 2 months have gone. Nah? When were you transferred? 3 months have already gone. Then that means 5 months is left. Then 8 months is left. Let him be peaceful. If you want to take action against some disciplinary action, take it. There's no quarrel with that. That is your lookout. But otherwise, okay, we'll take it up after some time.
Lordship.
And you get hold me a judgment on malafide, because otherwise the scope is very less.
Well, Lordship, is item number 1, state to PM.
May I please, your lordship? My lord, this is a similar matter, my lordship was pleased to dispose of on last Friday, my lord. My lord, notice is issued separately to this present school, my lord, that page 138.
Where are notices here?
My
Where are the notices?
This is page 138, last page of the petition, annexure 10.
How many petitioners?
Only one petition, my lord, the school.
And another is
My lord, the president and the principal is before my lord representing the school. My lord.
What school is this?
This is a, my lord, high school, privately managed school, my lord, under the Assam Non-Government Educational Institution Management Act of 2006. Permission has been granted.
Where is the permission?
Yes, my lord, may be pleased to find, my lord, at page 57, my lord.
This provisional permission is only for 1 year.
My lord,
What
now
happened there?
the school is still functioning and the at present, my lord, maybe please to.
How are you functioning?
My lord, at page, my lord, page 60 is another order, my lord. 57 is at 24/5/23 and this is of.
What are same?
My lord,
Then? There's no other order, this is the same order.
my lord.
Then twice enclosing doesn't make it a separate year. Shall obtain permission under the right to children to free and compulsory education within for elementary of within 1 year.
Within 1 year, my lord.
Then
The school authority shall obtain permission under this branch of 1 year, my lord.
what happened thereafter?
Perhaps that order has been issued, but we could not annex the same before my lord, my lord.
These are all 2013.
My lord,
One is 13, one is 23.
my lord.
Then
Permission for school code number of registration of student is also there, my lord.
have you sought for settlement?
Lord, we have applied for the settlement of the land also.
Where?
Yes, Lord, my lord, this to find page 56, my lord. By the president, my lord.
Where is the acknowledgement?
My lord, my lord can find the original is at page 69, my lord.
No. This you cannot apply like this.
My lord.
Huh?
My lord, application form for settlement of land in Greater Gauhati Part A, particulars of the applicant, my lord. Page 69. This is the format they have. Lord. House and 19 million. No decision thereafter, my lord. Under this,
Yes, Mr. Talukdar. What do you say?
Application is by the petitioner in his personal name, not in the name of the school.
This is the same type of notice given.
When?
Exactly same. Earlier when I was, the order which I have shown,
Yes,
those were quados petitioners. This is quad the school.
school.
Same orders will.
Same order, only the application was filed in his personal capacity, not as a school. At page 69.
Applicant is, you have taken it as a personal capacity. For what purpose? This is nothing to do, Mr. Counsel.
my lord, he is the president of the.
No. This is not for school.
Arve kaase, duta
No.
aase na?
It's not for school.
Duta aase na petition. Second to.
This land where I.
Bakkar Siddiq Mullah.
is Any issue or it is my personal capacity, my lord. I can reject also.
My second petition to Bakkar.
You see,
My lord,
what way the land is encroached
my lord,
by constructing dwelling houses.
my lord,
You have taken as a member of family.
my lord.
You are not, the purpose of the land is business. Why the land has been taken is not mentioned for personal reasons.
But admittedly, school's purpose has not been mentioned. there.
Then-
That is admitted. my lord. Yeah,
Okay, and why there is a 1702 is being mentioned here by hand?
no, my lord, in the notice also, my lord, they have also mentioned two Dutch numbers, my lord. At page number 38, if my lord may be pleased to find, that they have mentioned 1699 and 1702. Two Dutch numbers have been mentioned, my lord. Like that, my lord.
ঠিক আছে, এইটো অৰ্ডাৰটো এয়াই কৰি দিব, সেই আগৰটো নিচিনা কৰি দিব, কিন্তু খালি এপ্লিকেশ্যন ফাইল কৰা বুলি নেলিখিব।
My lord,
No, we are not going to recognize that you have filed application.
all right,
Come on.
my lord.
Disposed.
Dispose করুন।
Petitioners are, my lord, that is shareholders as well as employees of Assam Bahumukhi Samabaya Committee. In 1993, my lord, the society was registered. And my lord, in 2013, there was a change in bylaws. And my lord, after the amendment of bylaws, there was gross mismanagement of the affairs of the society. And huge sums of money belonging to the petitioners as shareholders, and the employees were also not paid. And my lord, being aggrieved, they approached the authorities. And accordingly, a 9-member inquiry team was formed. And an inquiry report was prepared, which starts at page 145.
Who are you?
Here to my lord, shareholders as well as employees of the society. It was at our expense, my lord, all these financial irregularities were committed. And that is why we had to come before your lordship. Initially, we approached the authorities, and after we approached the authorities, my lord, an inquiry was conducted. And that inquiry report, my lord, we find at page 145. Page 145, my lord. May I just read out the. In compliance to the government letter number so and so, dated 11/10/2022, an inquiry team was constituted by order number so and so, dated 11/10/2022, with 9 officers from different establishments of the department. And my lord will see in the. And my lord will see the allegations in the middle. The allegations are, number 1 allegation. The secretary of the society has.
So there is a report being given by the additional Jonas, joint registrar and additional Iman.
My lord, my lord.
Then what happened?
Then my lord, these are the allegations. And the allegation 1 is, if my lord kindly turns to allegation number 1.
No, then what happened?
Then my lord, the operative portion, page 149, man.
That I've read it. Then
My lord, there was an audit. In fact, an FIR was also filed against the respondent number 7, and there was an audit observation report. And in fact, they gave a show cause notice also to the respondent number 7, man. Now, after this, we had to come before your lordship. Even in the show cause notice at page 165, my lord, we kindly see, my lord. Page 165. Serial number 6. So one of the allegations in the show cause was records reveal that an amount of rupees 2.63 crores was collected by the head office from their employees in the head of the employee equity share from so and so period to so and so, which has not been accounted for. And then, my lord, we represented before the ROC, which my lord will find. It starts at page 183, and the relevant.
now what has happened?
Now I'm being told by my learned friend that all the prayers, the subsequent, my prayers are at page 53 to 55. Page 53 to 55, my lord. I've been told that prayer except prayer A, all the prayers they have granted relief.
Where?
Prayer A is there. And prayer B, C, D. I've been told that, my lord.
B, C, D, your lordship, that has been taken care of by the.
Prayer A. To settle the dispute between the petitioner and the controlling as so and so by so and so. B is initiate steps to remove the present secretary.
That
They are
has been
taking
done, that has been done.
done. It will not be issued directly
has
to
also
the
been done.
respondents to amend the bylaws. What is C? It is being done.
That
has been
they
done,
have
yeah.
changed the.
Then should not be issued to conduct the AGM. Done.
I've been told that in January.
January, 9th of January, new AGM has been done and the new board has formed, your lordship.
So what remains?
Only prayer A. Now,
What is prayer A?
Prayer A. If your lordship kindly sees my representation at
thank
page
you.
1, it starts at 183 and page 190.
Wait. Let us see. What is 92, 93?
92, 93.
Reference of dispute.
Settlement of dispute.
No, the dispute is already getting settled.
No, only one dispute remains, my lord.
Which one?
With regard to the money which they have misappropriated.
Ah.
our salaries as well as our shares. That may kindly be looked into by the ROC, my lord. That is my simple limited prayer.
Otherwise,
ROC is
Lordship,
doing it.
the latest instruction which I have received is that amount of rupees 17,16,784 has already been recovered, Your Lordship.
No, therefore, no, you see, dispute is one thing. What is 92? Let us see 92.
Section 92, my lord. Chapter 7. Settlement of disputes.
Any dispute touching the business of the society other than a business relating to disciplinary action taken by a society against an employee or so and so shall be referred to the register for decision, and if the parties thereto are amongst the so and so, the register on receipt of a reference shall decide it. This is 92 and 93.
92.
Now the register had issued a show cause to them.
Show cause to the respondent number 7.
Then
But my lord, my grievances, my primary grievance is the money which were misappropriated from the petitioner's salaries and the share. That aspect, my lord, once they recover it, because the ROC will know better as to whom should be paid how much. The details of those, my lord.
so there will be an official liquidator who will appear once the money has been recovered. As per this act, somebody will, the person who will be disbursing. The register will look into that.
Register will look into that. Register will look into that.
So that they are already doing it.
They're right now.
Yes, we are conducting it, Your Lordship.
Then
Otherwise, a sum of rupees 17 lakhs has also been recovered, Your Lordship.
so once the amount is being recovered, that amount how it is to be paid.
Yes,
you are-
Lordship, that will be done by the department.
They are doing it. Then what is there for this litigation?
So that only that observation, once they complete the exercise, my lord, they will, whoever is entitled to whatever amount, my lord, that may be taken care
I
of.
can say only that the petitioners Yeah. Or of the liquidator of the society. Kindly say, who is the liquidator of the society?
It has not been, Lordship, it is not under a liquidation process yet, Lordship. Lordship.
See, or of the liquidator of the shall be referred to the register. No, it has not reached, but there is a person who would be making the payment once the amount is being collected,
Lordship.
recovered. Who is going to do that?
Lordship, an official departmental officer on management has been given the job, Your Lordship.
But that has also been done. Then what remains?
Once they recover it, my lord, after that they will have to disburse
Then you have to make your individual claims.
claim.
Yes,
Then
yes, Your Lordship.
Claim.
what is there? Nothing remains.
So at least that, my lord, the register may look into that aspect, my lord.
No, register one. There is already an officer being
Yes.
appointed who is now looking into
Yes.
it. One-man committee. One man?
Not one man, Your Lordship, because recently the board has formed and they have got new chairman, Your Lordship.
Who's-
New
who's-
chairman has been appointed, Your Lordship, based on the AGM held on 9th of January 2026. Otherwise, prior to that, given the job to make the collections from the cash in hands of the branch managers of the state society. And now-
Understood. No,
Yes.
all these things is done.
Yes.
But who is going to make the payment to them?
Now, Your Lordship, as the board has formed and the chairman is there, based on the.
It will be decided by the board.
Yes, Your Lordship.
Why should the register be involved? Unless
Now,
there's a
now,
dispute.
now the register doesn't have any work.
No,
with
we
the-
will say, we can say that all the other reliefs have been duly here.
Yes.
The only relief remains is as regards A, which pertains to as regards certain amounts which is sought to be recovered by the departmental officer from the
branches of the state society.
branches of the state society. Once such recovery is being completed or partly completed, the petitioners herein shall represent before the chairman
Lodge.
of the society, and the society, if there is any problem with that, the petitioner can approach the register.
Lodge.
That is the fair.
Lodge.
Heard Mr. A.K. Burwa. A.K. Burwa. The learned counsel appearing on behalf of the petitioner, Mr. G. Bodlo, appears on behalf of the Corporation Department of the Government of Assam. Full stop. The petitioner herein who are members of a society in the name and style of, who are members of a society, a cooperative society, namely the Assam Bohumukhi Samobhai Samiti Limited, are aggrieved by certain actions committed by the then secretary of the said society. Various reliefs have been sought for in the writ petition. The council appearing on behalf, it is submitted at the bar that the reliefs being numbered as, and the reliefs at B, C, D is already being taken care of by the Cooperation Department of the Government of Assam. Insofar as the relief A is being submitted, that there are steps being taken by the departmental officer so appointed to recover the amount from the various branches of the state society. Mr. A.K. Bolwa, the learned counsel appearing on behalf of the petitioner, submitted that a direction be issued upon the register cooperative society to thereupon distribute the said amount amongst the various employees of the said society who are entitled to. Mr. G. Bordloy, the learned counsel appearing on behalf of the corporation department, submitted that on 7/1/2026, 9/1/2026, a new board of directors have been constituted pursuant to the AGM held. And therefore, it would be proper on the part of the petitioner as well as those aggrieved to approach the board for release of their dues. He further submitted that in the circumstance, the board does not consider such request, the corporation department shall do the needful. The register of the cooperative societies shall do the needful. Taking into account the above, the instant writ petition therefore stands disposed of with the following observations and directions. Number one, as the relief so sought for by the petitioner at clause B, C, D have already been taken care of by the Cooperation Department of the State of Assam, no writ is required to be issued in the present facts and circumstances. Insofar as the relief pertaining to relief sought for at serial number A of the writ petition, it is observed that once the departmental officer of the corporation department recovers or partly recovers such dues from the branches of the respondent society, the petitioners or those persons who are entitled to any amount would be at liberty to approach the board of directors of the Assam Bohumukhi Samavai Samiti. It is further observed and directed that in such circumstances, the board of directors of the Assam so-and-so shall carry out the shall consider the same. It is further observed and directed that in the circumstance those members are members of the petitioner society, respondent number so-and-so society are aggrieved, they shall be at liberty to approach the register of the cooperative society in terms with section 92 and 93 of the Assam Cooperative Societies Act 2007.
Let's do. So the petitioner's land on the, just for number 3. Initially, that was for 1 aplesa, that was increased to more than 40 years. Now almost 7 years, 1 10 lesser land and it can occupy. And they want construction for the name of the project. Earlier, it was one of the beautification of and development of the eco team of river Moravur from Polwa Sabili to Kalanguru Dishnava, our Samadhi. Now this project has been seen. Now the bank protection will be river Moravur from Polwa Sabili to Dishnava Kalanguru. This is without following any procedure under the land acquisition.
Yes, what is this?
Lordship, regarding the land of the petitioner, which the petitioner has claimed, Lordship, the land availability certificate which the Water Resource Department has received from the circle officer, the dark number of this land and the dark number of the petitioner land is different, Lordship. This is the land availability certificate, which in fact we have already stated in our affidavit also that the dark number of the petitioner land and the land which the Water Resource Department has used is different, Lordship.
Paragraph number
7, Lordship.
Ownership of the petitioner's land is at Pepe Patta number Iman, whereas you want to carry out the beautification where?
Government Dag number 182.
182. They are trying to say it is a 182.
182, Government Dag. We have also filed an appeal.
182.
Yes.
Okay. Nothing remains then.
But interestingly, one of the land, my land that has been one of the, by way of execution process, I have been one of given permission by the court, by this restaurant of the court.
No, they categorically say that your land is dark number 145 or PP Patta number 45. So they are not going to do anything.
Why not? It is already covered my entire land has been captured. Because one of the my land and 182, this is a minor border. After 182, my land is started my land. And this is land 182 is come under the one of the Putlong, this is Mojal, and my land is one of the different shooting. So this is the different, and they have approved the cadastral pillar. That is why I have made the party the director of the land surveyors. They have to file their affidavit. Otherwise, the commission has to be appointed. Then, decided because they are claim whatever is totally false. Kindly, I want to show one thing.
No, have they today constructed already?
Yes, already encroachment almost encroachment already construction project will completed almost. It is started from 2023. I initially was objecting and initially one thing, Lordship will come. They are affidavit response number 3, my lord. Kindly see, my lord. Although they have raised para 7, they have stated that they have not encroached my land.
Where is your map? Revenue map.
Revenue map, my lord, I don't have, my lord.
Why?
I can produce, my lord.
That is the most essential thing.
Yes, my lord.
Then how do I otherwise find out? Because these are disputed questions of facts.
Yes, ma'am.
They are saying on another hand that this land is in dark number 182.
Yes.
You are saying it is in dark number 145, PP Patta number 45. How will this court decide?
I have appointed a commission, my lord. Court can.
Commission on this court has to be prima facie satisfied.
This is why I am satisfying, my lord.
I am not satisfied on the basis of these documents. How will you know on the basis of these documents it is not?
My lord, please see, my lord, one of my next one.
What is that?
This is Alexa code and page 51. This is a project, my lord. Project my document, my lord. Where Lordship will get
Annexure?
Alexa code and page 31 of my read.
Page? This.
Lordship will get in the right side of the top. There is a my lord, the date should be.
Where is your land?
This is my land, my lord. This is the marking is there. This is my land. That has been already enforced.
Which is your land?
This before she does a marking is there, my lord.
Huh?
The project, my lord. I just
How much is the area of your land?
that has been not mentioned, but the project it has been shown. This is entire.
How much is your area of your land? What is the boundary of your land? Because you got the land possession on the basis of some decree.
Yes.
So therefore, there will be the four corners of the building, of the land. No. Where's your decree? This is the most important thing. Now then only we'll come to know what are the four corners of your building, of your land. Which map? Oh, you file it. Heard Mr. P. Mohanto, the learned counsel, appearing on behalf of the petitioner. Mr. R.M. Das appears on behalf of the Water Resource Department. So and so appears for the district administration. The case of the petitioner herein is that he is the owner of a plot of land at measuring 1 bigha, 8 bighas, 1 katha, 10 lechas, covered by Dag number 145 or Patta number 45, village Bitor Suti, Moza, Bhairav Pad, P.O. Kolia Bhomura in the district of Honitpur. It is the case of the petitioner that in the name of carrying out beautification by executing in the name of carrying out a project, namely beautification and development of ecotourism of river Mora Bharali from Porua Sariali to Kolagaru Vishnu Prasad Rabha Hamadhi. The respondent authorities have encroached upon the land of the petitioner. However, from a perusal of the affidavit which has been filed by the respondent number 3, it is submitted that the land wherein the project is being executed is at Dag number 182 and not the land belonging to the petitioner. This very aspect is mentioned in paragraph number 7 and 8 of the affidavit filed by the respondent number 3. On the other hand, the learned counsel appearing on behalf of the petitioner submits that the land belonging to the petitioner is adjacent to Dag number 182, and in that process, the respondents have encroached upon the land of the petitioner without proper demarcation. During the course of the hearing, Mr. P. Mohanta submitted that the land in question, the land of the petitioner, was handed over by the executing court in pursuance to a decree of the court. Under such circumstances, the four boundaries of the land would be mentioned in the decree. However, the decree is not on record. In addition to that, there is the revenue map of the land of the petitioner have also not been enclosed. Such disputed questions of facts cannot be decided in absence of such documentary evidence. Mr. P. Mohanta, the learned counsel, submitted that he may be given given leave to file an additional affidavit bringing on record the decree of the court, as well as the revenue map of the land belonging to the petitioner. So taking into account the above, list this matter again on 25th of March 2026. In the meantime, liberty given to the petitioner to file the additional affidavit on or before 23rd of March.
Lordship, one more submission was there. One more submission was there.
Yes.
Lordship, that additional affidavit we have filed in page 52, para 6, we have categorically stated that the land which the petitioner is claiming is a Bautoli land, and there was an ice factory of the petitioner which was already been evicted by the district administration on 12/7/24.
Let him file. We'll see on next date. You make that submission.
We
Not any NOC.
We have-
Such not that my aspect.
we have already attached the order also.
It's okay. We'll see on that day. Yes, what is this?
Land acquisition matter. Land was acquired, matter, no compensation has been given in this. Compensation has also been not been given, no award has been done. The last petition, honorable court was pleased to take direction.
When was the land acquired?
The year 20 and 21. Last petition by there was a direction seeking instruction.
Land was acquired in the year? Then? No. Compensation has not been paid to you. The land has been acquired.
Acquired without following any.
Possession?
Possession has been taken.
Which is the document?
No notice, nothing has been given, madam.
We'll see, notice or no notice, it's okay. Where is the award?
No award is also.
Huh?
No award
What is the stand of the respondents?
to the whole case. That's why on the last case and inspection were performed.
In fact, my lord, we have sent it to the finance department, and last occasion, my lord, A. Bhattacharya was directed to take instruction on that, my lord. Revenue department.
Have the land of the petitioner been acquired?
Yes, my lord.
Acquired?
Yes.
Have you paid compensation?
My lord, regarding the revised.
Under what provision have you acquired the land?
My lord, there is a dispute regarding the amount and the valuation.
I'm not on that. Under what provision have you
My lord,
acquired the land?
under that, the Land Acquisition Act only, my lord.
Which one? There are three.
My lord.
Which one?
That is not mentioned here.
Have you
In
filed
in
the
our
affidavit?
affidavit, it is not mentioned, my lord.
Madam, this is a matter of 2024.
Yes, my lord.
And the affidavit which is filed by the respondent number 4 is bereft of any details. And you see, there's nothing mentioned out there. Whether the land has been acquired or not. Nothing is mentioned. See? Here the petitioner categorically says that the land has been acquired,
My lord.
but no compensation has been paid. Then no affidavit has been filed. Notice has been issued as far back as on in the year 2024. Madam, this cannot happen like this.
My lord, in our affidavit.
It seems that counts the, which department, water
Water
resource?
resource, my lord.
They don't want your service. Let's see the face of the chief engineer, water resource department. The next state.
I'll just get the appropriate instructions. my
No
lord.
instructions
My
can
lord,
help. Madam, instructions cannot help this cause of yours. Only thing that can help is an affidavit to be filed by
My
the
lord.
chief engineer, water resource department, stating clearly whether the land of the petitioner have been acquired or not.
My lord,
And if it has been acquired, when, under what provision, and compensation has been paid or not.
My lord, I'll
These
file
are
one
the three
consolidated.
things we require on affidavit.
My lord.
Next week.
My lord.
Both the matters are same?
Yes, my lord.
One order. To stop.
Lordship gives me 10 days time, my lord. 10 days time.
Huh?
10 days time.
Okay. The petitioners in both the writ petitions are aggrieved by action on the part of the Water Resource Department of the state of Assam in taking over the possession of their land in construction of a dike. Dike, na?
Yes, ma'am.
In the year 2020, and without following the mandate of Article 300A of the Constitution, the council appearing on behalf of the petitioner submitted that the land of the petitioner lands of the petitioners have been taken without applying the authority of law, or without applying the relevant provisions of law. That is, without applying the relevant provisions of the acquisition laws. First, though the lands have been acquired, possession of the lands have been taken as far back as in the year 2020. Till date, the respondents are silent on the said aspect. This court have also taken note of that both the petitions have been filed in the year 2024 And in the early part of the year 2024, there were directions issued, notices issued asking the respondents to show cause. But till date, no affidavit, till date, no affidavit has been filed in WPC number 1490/2024. However, an affidavit though has been filed by the respondent number 4 in WPC number 902/2024, but it is bereft of any materials. Under such circumstances, the respondents herein are directed to the respondent Water Resource Department is directed to bring on record their stand by filing their affidavits. First, the affidavit has to be filed by an officer of the rank of Chief Engineer, Water Resource Department. The affidavit shall mention the following details. Number one, whether the land of the petitioner in both the writ petitions have been taken over. Possession of the land of the petitioners in both the writ petitions have been taken by the respondent department, Water Resource Department. Number two, if taken, what is the area of the land which had been taken by the respondent Water Resource Department? Number three, if the land has been acquired, the said land has been acquired under what provision of law? Number four, as to whether the petitioners have been paid their due compensation. First, in addition to that, the district administration of which district? Dhemaji. District administration, the district commissioner Dhemaji, who is a respondent. Is he a respondent?
Yes.
Is also directed to bring on record its stand in respect to the lands belonging to the petitioner in both the writ petition. Giving details as to whether any acquisition process was adopted prior to taking over the possession of the lands belonging to the petitioners. First, the affidavits has to be filed on or before 18th of March 2026. First, list this matter on 20 March 2026.
Item 17.
My lord, in this petition, asked image to time 23, but
As committee,
This
as committee, they are not sending these people.
they wouldn't send, but they have taken the air card for a chartered flight, my lord. It is much higher than the scheduled flight. But they have provided the scheduled flight, my lord. Kindly refer to page number 65, my lord. It is mentioned by the state health committee. Page number 65.
Now, what do you want?
The refund, my lord. They are not, my lord, paying the refund amount. That is the difference of the scheduled flight and the chartered flight.
Did you go to Hajj?
Page number 65.
Did these people go to Hajj or not?
Yes.
You had the pilgrimage.
Yes.
Then
But they were taking,
why you are after doing all these things? Why you are again fighting?
they have taken much amount
How much they have taken?
of that amount. The chartered, yeah,
Then
from the scheduled fare.
Then?
Kindly page number 65 for the moment.
so what?
It is not a minimum amount, madam. From
How much?
65, my lord, page number 65.
Where?
Okay,
Moreover, this year no chartered flight was provided from Gauhati embarkation point, and instead pilgrims were carried by scheduled flights. This has caused resentment among the pilgrims, following which several claims is being made by the pilgrims for refund of the excess amount being so and so. As such, you are requested to consider the matter in the greater interest of the pilgrims of Northeast India. This is being written to the Chief Executive Officer, Hajj Committee. Then,
now on page number 83, kindly
No, 83, what was the fair they collected, my lord, first committee?
80?
83, my lord, yes, affidavit. They did not deny that, there was no, not a-
How much they took? 1726.
17 the dollar, if it is converted to rupee, it is more than 1 lakh.
So how much they should take?
But in the schedule.
This is up down.
Up down.
Oh, then
But when in a scheduled flight, my lord, it is much, my lord.
it is less.
Yes.
From Guwahati. Tell me which flight goes from Guwahati to Jeddah? Ah, you have not gone to Hajj? No, you have not been to Hajj.
Yes, sir, yeah, 2006, my lord. Or
2006. And you went from where? Bombay?
No, from Gauhati.
Okay, so
6,000. It was.
see, 90,000, 2006. This happened in 2023. So,
But this amount, my lord, about more than 1 lakh, my lord.
this is not 1 lakh. I think you have already done it. Hajj charter flight in here, how much they have spent or not, go and file before the civil court. Circular amount payable by the selected by Hajj so and so. Guwahati is 3 lakhs. Amount payable is how much? Balance to be paid by Hajj so and so is 3 lakhs 82. So,
Their affidavit, they did not deny my receiving this.
Your lordship, similar matter has been disposed of, your lordship, that tagged matter is disposed. This is the order, your lordship.
what the court has passed?
Your lordship, kindly do.
Now, this court is not going to pass this type of thing.
Under section 42.
This is not going to help it. Go to the civil court. You have time. Go there.
Not dispute, my lord. It is not dispute in the affidavit, that is not disputed that we have not paid for the charter time and we have not, they have not provided. In the affidavit, not disputed.
So what is the scheduled flight rate? Because from here, there is no flight which goes to Jeddah.
It is.
So therefore, it has to be some flight.
Yes.
Which is the flight?
My lord, that's the discussion.
Now these persons went from here directly to Jeddah.
No, ma'am.
Where?
They, some to Delhi, and from Delhi to Jeddah, some to Bombay, and to Delhi.
So from here, how did you go?
My lord, if the charter flight, it is directly, only the pilgrimage taken directly to the Jeddah or the.
So from here it went to this place.
Yes, ma'am.
But you were willing to pay that amount.
When was the provided the service?
No. This is not the case.
The fare is taken, my lord, but not out of the. They have not provided the service. And there is nothing in the affidavit, my lord, that they have not, my lord, taken the amount for the.
But you have not provided the details, how much it would be if the flight is taken from here. All of you two went together.
Yes,
all of these petitioners.
All the petitioners.
One flight.
Different flight, lord. Some to the Delhi, some to the Bombay, different flights.
So then,
Only grievance is there, my lord. The fare is taken for chartered flight. There is the.
so what?
The state first committee also, my lord, admitted, and the first committee of India also admitted.
You
that-
should be happy. Take it as a zakat, giving it to them.
I am not. Oh, I don't.
Take it as a zakat, give it to these people.
The respondents find the amount, when what is the amount difference of the civil flight in the.
No. This is not a case for that. Who is paying for the House committee?
We have filed our affidavit.
So you want a similar order like this?
Your lordship, that tagged matter, this matter has come along with that, your lordship. That one is disposed of, your lordship.
Hello, Econ Cycle dispose করে দিব. A2 one. We dispose it like this, but this is.
petitioners have been evicted, my lord. Our contention was that, my lord, the area over which the petitioners were living, my lord, was not, my lord, forest area. My lord. It was all along, my lord, revenue and, my lord, ultimately, my lord, during the pendency of the petitions, my lord, they have evicted us, my lord, and today, my lord, they have filed on legitimate opposition, the annexing one page instruction.
You have been evicted?
Already evicted.
Then what to do? What can we do?
This was not open, my lord.
Huh?
This was not, my lord, open.
But you have been evicted. What can I do now? You are asking for quashing of the notice. Then a REIT in an area should not be directing, more particularly not to evict, directing joint verification. Then
Then, my lord, I have filed.
petition has become infructuous.
My lord, I have filed IA, my lord, that is pending, that has come up with.
Mr. Counselor, by highway nothing can happen. You have been evicted, then you have to ask for compensation or rehabilitation. Can't help it.
IA, my lord.
IA would not, IA is a separate, this is a separate cause of action.
Given, my lord, additional educated, my lord, for Kita copies, my lord, which shows, my lord, this is not forest area, my lord. They are silent, my lord, they have not given.
Then you say, challenge it. Challenge the eviction. Challenge the eviction that this land has been taken with, these are my land, these are not forest lands.
What land also, revenue land, revenue land.
So understood, so therefore you have been given a patta. Patta?
No.
Who are you?
Tosi Bhajan.
Tosi Bhara is government land,
Yes, ma'am.
but they say it to be forest. Then reserve forest.
That is wrong, my lord, not forest. They have extended the area, my lord, as per their choice, my lord. Today one step, next day, my lord, another 2 steps, my lord, in this way extended, my lord, even the revenue has been brought under forest land.
But Mr. Counsel, how do I help you with this petition? Your IA cannot help you. You have to file a fresh one.
Leave it to your lordship, my lord. So to.
No, the only way is the fact that you have already been evicted.
Already.
So you are therefore to challenge the eviction and also seek appropriate directions.
Well.
Don't you think that? Mr. So-and-so heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, Mr. B.J. Talukdar, the learned senior counsel assisted by Mr. P.K. Medi, appears on behalf of the revenue or the state?
State.
For the state authorities. Mr. I. Botago appears on behalf of the Forest Department. Full stop. The petition counsel for the petitioner had submitted that during the pendency of the instant with petition, the petitioners have already been evicted. He therefore submits that he may be permitted to withdraw the instant with petition and challenge the eviction, including what has been challenged in the instant by without prejudice. Without prejudice. Full stop. Taking into account the above, the learned counsel also submitted that the lands in question were not forest lands and were revenue lands, and the forest authorities therefore did not have the authority to evict the petitioners. He submitted that these aspects would be challenged if liberty is given to the petitioner to file a fresh writ petition. Taking into account the above, the instant writ petition stands closed. On withdrawal, liberty given to the petitioner to file a fresh writ petition challenging the eviction and seeking further relief as entitled to which the petitioner is entitled as per law. This court further observes that the withdrawal of the instant writ petition shall not cause the petitioner to this court further observes that the withdrawal of the instant writ petition shall not cause any prejudice to the petitioner. I stands closed.
My lord, in this matter, the Lok Adalat award sentence on the ground of fraud committed by the respondents.
Is it? Then what happened?
My lord, I am one of the Pattada. I was not made a party in the suit. I am a Pattada. I was not made party in the suit. The suit was behind my back, compromised behind my back, and now they have distributed the property into 3 equal parts among them. And I have been left.
So you are challenging the Lok Adalat
Lok Adalat award, the ground of fraud committed by them.
Okay. Taking into account that the affidavit has been duly filed, pleadings are complete?
Yes.
Pleadings are complete. List this matter for final disposal on 12/3/2026 at 2 p.m.
Item 28.
My lord, on last occasion, my lord, on submission has been made that the respondent number 7 has been, my lord, constructing, my lord, in my, under Haflong Municipal Board. Land was given was by Haflong Municipal, does not belong to the council.
Affidavit, no affidavit filed? You are appearing for?
For respondent number 7, my lord.
What do you want to say?
My lord, it was settled in the year 2009, my lord, in my favor, my lord. The land was settled in my favor, my lord, in the year 2019, my lord.
Then?
My lord, and I have, sorry, 2021, my lord. And I am possessing the land, settlement order is there, my lord. And subsequently, my lord, annual Khiraj Patta was granted in my favor, my lord.
Why you are not filing your affidavit?
Oh, my lord, otherwise it is ready, my lord. I am going to file today itself.
Dimaso.
Dimaso, although Dimaso is the made party, but chairman, Haflong Municipal Board is the appropriate
Hmm?
authority. Lordship Chairman, Haflong Municipal Board is the appropriate authority.
Who is he? You are appearing?
No, Lordship.
Why?
Notice has to go.
But this was filed, my lord, before them. In spite of that, construction over my land, my lord, they are doing it, my lord.
We'll look into it. You file your affidavit. Was there a stay? Stay is given, na?
Hearing order, my lord.
Huh?
Hearing order, my lord, but the impugn notice was not paid, my lord, page 41.
Now, my lord, 2021, my lord, I was settled with the land, my lord.
That there shall not be any eviction to evict the petitioner from the subject plot till the next date.
Protecting me, my lord. The thing is that the order they obtained in 21, my lord, they have done the construction in 24 in my land. And this is cannot be allowed because land belong to municipal board. And they have already settled in my favor, my lord, municipal, from 1961, my lord.
Which land, which order you are challenging?
Page 39 and 41, my lord. Page 31 is the order, my
With
lord.
reference to the so-and-so, I am directed to inform you the land measuring so-and-so situated a Haflong 1 behind Bataso is hereby allotted to AK Patta on AK Patta by curtailing the land of Haflong municipality on payment of.
It was already allotted to me by Haflong municipal.
Okay. So land by curtailing the land of Hafcom Municipal Board. Who are you?
And I've already allotted to me, my lord.
But there is no area mentioned. Where is your allotment? Huh?
Allotment is there, my lord, from page 36. From my father time, my lord.
Where is your allotment?
Page 36, my lord.
Page?
36.
Hereby notified for general information that the land measuring so-and-so by so-and-so square feet in the area of holding thereon governed under town committee. Holding number Iman of Nogor, Haflong, standing in the name of so-and-so is going to be transferred in favor of so-and-so. Anybody having any objection to the proposed transfer of demand can do it within so and so. So this is given by the chairman, town committee. Now it is municipal. Okay, but this is belongs to somebody else land.
No, case 39 will also. Case 36.
No, 39 is a half-long municipality's land. Here, this land belongs to somebody else.
Ram Sundar Kahar is my father.
Understood? Ram Kumar Kahar's is being transferred in your name.
Yes.
Okay. So this is, how do you know that this land was belonged to the town committee? They have only given out here by only the half-long municipality's land.
Page 44, your Lordship.
Page?
44.
Yes.
The holding ownership certificate number.
As holding number so and so, registered under the municipal of Haflong Town Committee as holding number 204. Now, whether 204 is his land?
No, my lord, with due respect, my lord, this is a vacant land.
Taking into account the various disputes, this court is of the opinion that an affidavit by both Haflong, by the chairman Haflong Municipal Board, as well as the respondent number 7 would be required. First of taking into account the above, list this matter on 27th of March 2026. In the meantime, the respondent number 5 and 7 shall file their affidavits. First of, in the affidavit to be filed by the respondent number 5, it shall clearly be mentioned as to whether the land belonging to the petitioner was allotted to the respondent number 7 or not.
My lord,
the pastor Elias shall continue till the
respondent
next.
number 4 may also file, my lord, because settlement was made by the settlement officer, my lord. Settlement order was issued by the, my lord.
We have I am correspondent number 4. Lordship, we are acting based on the report submitted by the chairman municipal board.
Okay, you can file it. Okay, respondent number 4, 5 9. Yes, next.
Apply.
Today morning, council, they filed their affidavit. I need to respond to this. I may be also allowed to.
Your name?
And so.
Mr. M. Chaudhary, the Learning Council submits that the Karmi Anglong Autonomous Council has filed an affidavit today and he would have to place it before the petitioner as to whether the petitioner would like to file a reply. Okay, Mr. Siburu appearing on behalf of the NHI also submits that he would like to file an affidavit in opposition. List the matter again on 27th of March 2026. The petitioner would be at liberty to file reply to the affidavit in opposition filed by the Karbi Anglong Autonomous Council on or before 25th of March 2026. The NHIDCL shall file their reply to the affidavit to the petition on or before 16th of March 2026. Petitioner
Affidavit.
You have filed.
Affidavit has not yet been filed.
You want to file, na?
Affidavit not reply, my lord. Affidavit in opposition has not been filed.
File the affidavit in opposition on or before 16th of March 2026. First of the petitioner, if so advised, would be at liberty to file reply on or before 25th of March 2026.
Right.
My lord, in 23, Lordship, allotment has been done, Lordship. In item 23. And in item
Allotment given, payment made. Then
in item 23, it was corrected, Lordship. Land has been corrected, recorded. In item 22, Lordship, I have not received the instruction, Lordship.
Okay.
Similarly, we can dispose of.
wait. Item 23, where is your instruction?
Item 22, receive instruction. In item 20, we have received instruction from district commissioner. Yes, it is.
It was 23. Oh, ये नहीं सोचा. Corrected.
So I think you need to file an affidavit because he has to reply. But have you cancelled the allotment then? The fact that an allotment has been given is not denied.
This is it.
But what you are now saying that the petitioner has suppressed the fact that he has alternate land is not there. So therefore, if it is a suppression and the petitioner has land, then the petitioner is not entitled to settlement in terms with the land policy of 2019. So you need to file an affidavit. Ms. So-and-so appearing on behalf of the Revenue Department. No, you have to file the affidavit in this case.
But that
You filed it. Mr. S.S. Roy appearing on behalf of the Circle Officer, Gauripur Revenue Circle, Dhubri, submits that he has received an instruction to the effect that the petitioner is the owner of various plots of land. He further submits that the petitioner was granted, under such circumstances, the respondents would like to file an affidavit in that regard. Taking into account the above, the respondents, more particularly the circle officer, more particularly the district commissioner, Dhubri, is directed to bring on record the said affidavit, the stand of the respondent numbers 3, 4, and 5 by filing an affidavit. Full stop. List this matter on 18th of March 2026. The affidavit be filed by the respondents. Number 3 on or before 9th of March 2026. You can, nah? And see the other one, what is your
Other
instruction?
one, Lordship, it has been corrected.
Other condition, covers.
Para 7, Lordship. Para 7 has been initiated for record correction and sent to higher authority for approval, and which has been already been approved and recorded corrected. It will.
So has the patta been issued?
Lordship, yes, Lordship. Nowadays, no separately issued. It was only correction done, Lordship.
Huh?
No separate patta is
Patta is issued.
nowadays. Corrected. Corrected. Nowadays, not issuing, Lordship. They are not issuing correct. Only correction done, Lordship.
And in that it is being shown.
Shown, Lordship.
That the allotment has been done.
Yes.
Lordship, no separate patta has been issued, but as per your Lordship, the order dated so and so, there is a mention of.
No. Later on, they will have a problem. I don't think that they also, 1 year back when I was taking bench 5, I could see pattas being issued. And nowadays the patta is very nice. It looks very good. It has the geographical coordinates.
But my instruction said no separate.
Page 17, it is approval was given by the Deputy Commissioner. Page 17, annexure 2. The letter written by the additional district commissioner to the circle officer.
Prepare patta in favor of so and so.
There is the.
Process for renewal was initiated immediately after the receipt of the instruction and was sent to the, but due to some technical patta might not have been generated. Again, new so and so have been initiated for record and sent for the alia for which have been approved and record corrected. Okay. Ms. R. Chaudhary, the learned counsel appearing on behalf of the petitioner submits that in the meantime, during the pendency of the instant petition, the records have been duly corrected, whereby the petitioner's name have been recorded against DAG number DAG number? DAG number 2? What?
Patta number 234.
Can you give it to me? Corrected. Thereby inserting the name of the petitioner against DAG number 2 of patta number 234 of village Geramari 5th Khanda under Moza Al Mogo. What is that Moza? Moza is what? Moza. Moza so and so. Revenue circle, Goripur.
Goripur revenue.
In the district of Dhubri, Assam. To stop. This is for this court to keep it. The copy of the chitta as well as the Jamabandi have been placed before this court and are kept on record and marked with the letter X and Y. Good stop. Mr. S.S. Roy, the learned counsel appearing on behalf of the district administration, further submitted parawise comments which is kept on record and marked with the letter Z. A perusal of the said parawise comments reveals that on account of a certain technical problem, the patta could not be generated. However, the record correction have been made. The said instruction is dated 15th of September 2025 and almost 5 months have passed. Accordingly, list this matter on 18th of March 2026, on which date an update be provided as to whether the patta have been issued in favor of the petitioner. Because patta has to be issued. Without issue, you cannot on the basis, because I have heard arguments out here, allotment, payment, nothing will do unless patta is not issued. Because patta is the settlement.
In this case, 38 persons were selected and allotment were given, and now they are taking a stand that the petitioner of item 22 has some lands in other area. Already approval granted.
Let them file affidavit.
That.
24 and 25.
Okay.
What is this?
Sir, they file a reply to them, madam. They file affidavit in reply to them, madam.
It has been submitted that an affidavit in reply has been filed by the petitioner today. So taking into account Mr. B. Chakraborty appearing on behalf of the respondents. Number?
Respondent number 7, madam. 7.
7 submits that he would like to go through it. List this matter again on
Next week, my lord.
I am for response number 6, my lord.
urgency.
No, my lord.
Some urgency is there, my lord. It's a case of land grabbing, my lord. Taking the High Court's order, my lord, he has grabbed my land.
After 2 weeks, my lord, I am.
This is the matter on 2nd of March 2026. The registry shall bring on record the said affidavit in reply.
Item 26.
Qualification of Panchayat.
How?
He submitted false birth certificate at the time of death of my mother, and the petitioner submitted complaint for the competent authority and at the Deputy Commissioner's mother. And that complaint was forwarded for the execution by the Alexa team by the this complaint was forwarded to the title officer for execution by the. And my lord, the Alexa name, my lord, the parcel register, my lord, submitted verification report is parcel is not doing my lord.
Mr. Doctor, why you're not taking action under 11? 111, who is? Yes, DC, why you're not taking action under 111?
Lordship. Huh? No idea. Huh? Lordship, I am awaiting instruction to that effect, Lordship, not receive any instruction, Lordship.
Okay. List this matter on 25/2/2026. Full stop. The DC, the District Commissioner, Sri Bhumi, shall apprise this court as to why no action has been taken in terms with section 111 of the Assam Panchayat Act 1994, read with Rule 62 of the Assam Panchayat Constitution Rules 1995, in pursuant to the the complaint submitted by the petitioner on 30/6/2025, which was received on 1/7/2025. Okay.
Lordship, let it be on 27th, Lordship.
No, 25. You cannot keep on sleeping like this.
Lordship.
Item 27.
Okay, 27.
27.
Leave it on 27. Yes.
Yeah, my lord, there was a scheme in the name of the minister's COVID-19 window support.
Yes, why no instruction?
Lordship, the honorable court, my lord, already passed an order, 833, saying that verified inquiry into the matter.
This is 50 lakhs.
2 lakhs.
5,000, 50,000.
2 lakhs 5,000.
50,000.
What is this?
Well, widow support with the
Then?
person whose husband died.
Then speaking order passed where?
Speaking order passed on, my lord, 27/2/2025. That is, my lord, page 37. And found eligible. Page 39 is the relevant. Page 39. Lord, point number 10. Based on the finding.
Okay. So this order is being passed.
Being passed, my lord, but
Lordship.
not paid.
So we have been, that order has been forwarded to the Principal Secretary, Chief Minister, Secretary, Lordship. That is pending.
Your government should first, before making all these schemes, know that whether they can pay. What is the idiom? What is that? Cut one's clothes according to one's size, no? Isn't it? The petitioner herein, who is a widow of a COVID victim, who is a widow of a COVID-19 pandemic victim, is aggrieved by the non-release of the compensation of rupees 2 lakh. How much? 50,000. As per the scheme, as per the Chief Minister's COVID-19 Widow Support Scheme. This court also takes note of that the office of the District Commissioner South Salmara had also passed an order on 27/2/2025 holding inter alia that the petitioner is entitled to the said ex gratia payment. But till date, the respondent authorities have not released the ex gratia payment for which the petitioner has approached this court. The record reveals that this court had issued notice as far back as on 27/8/2025. Not to speak of not releasing the amount, the respondents don't even have the respondents have also not provided instructions to the standing councils.
May I submit one thing?
What?
Deputy Commissioner has forwarded to the Chief Minister office also. That was instruction I had also.
To the
Principal Private Secretary, Chief Minister, Assam Chief Minister's Secretary dispute also.
Then
That is lying there also.
so should we say that these schemes are just for the sake of it?
That is
When are you going to release it? Else I have no problem in mentioning it. These schemes are being made only just for the sake of it. You know what is the consequences? Not in good terms nowadays. Next week, release. Release. Next week. You cannot hold to this. A person died. COVID-19 is finished. We may have COVID-25 if I've got, if heavens again fall. You have to release. You can't have it like this. You have a scheme. You had the budget. There must have been a budget on the basis of that. Not to speak of not releasing the amount to the petitioner, to which the petitioner is entitled to. No effective instructions have been placed before this court by the respondents. Considering the above, where is the scheme?
Page 20, second paragraph. Chief Minister ने बताया है।
It is also mentioned. Accordingly, list this matter again on 6th of March 2026. In the meantime, the respondent number 2, who can give the money?
One.
No. You have not made the proper person a party.
Yes,
Na?
sir.
Who is to make the payment?
Lordship, Deputy Commissioner requested for sanction to the Chief Minister's Secretary, Lordship. Deputy Commissioner submitted a request for sanction, Lordship, to the Chief Minister's office, Lordship.
In the meantime, the respondents herein are jointly and severely directed to apprise this court why the amount of rupees 2,50,000 have not been released to the court, to the petitioner. Hmm. You have not got it.
My self-permission has been rejected my self-permission has been rejected on the ground that my lord some litigation, some my lord,
Title
title
suit
suit is
pending.
But they have not given any case number. We inquired in the office of the circle office. They have given the title suit number. Then thereafter, I have obtained the certificate copy of the plaintiff, my lord. I have seen my lord defendant in any of the names, my lord, in the column of defendant. My name is not there, my lord, and that number, partner number, totally different, my lord. My that number 322, partner number 1014, and land in title suit, my lord, that number 286, partner number 1007. Kindly see order sheet, my lord.
What is your instruction?
Mine say pending title suit, it was not given.
My lord, kindly see page 27, my lord.
E22. চিঠাটো টেটুৱে আছে বুলি কৈছে। চিঠা correction
No, 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 no. You are looking into 202, which court? Mr. Counsel, Mr. Roy,
Lordship.
which court?
That was not mentioned, Lordship.
Then? So, wait. Mr. SS, the petitioners had sought for a no objection certificate in terms with section 21A of the Registration Act 1908 as applicable to the state of Assam. The said application was rejected on account of a pendency of a civil suit. It is the case of the petitioner that there is no civil suit pending in respect to the land for which the petitioner have sought for the no objection certificate. Mr. S.S. Roy has played the learned counsel appearing on behalf of the Circle Officer, Dispur Revenue Circle, have placed the communication dated 6/2/2026, stating inter alia that as per the manual Chita records, it is mentioned that title suit number 202/2016 is pending against the disputed land covered by DAG number 322 of KP Patta number 1014 of Revenue Village Jotikuchi under Moza Beltola of Dispur Revenue Circle. Full stop. This court have perused Annexure 11 to the writ petition, which is the certified copy of title suit number 202/2016. The DAG number in respect to the said land in the said suit has no relation to DAG number 322 of KP Patta number 104 of Revenue Village Jutikuchi under Moza Beltola of Dispur Revenue Circle. Under such circumstances, this court further keeps the instructions so placed that said instruction is kept on record and marked with the letter X. Under such circumstances, the Circle Officer Dispur Revenue Circle is directed to produce the certified copy of title suit number 202/2016, wherein DAG number 322 of KP Patta number 1014 of Revenue Village Jutikuchi under Moza Beltola of Dispur Revenue Circle is pending. List the matter on 2nd of March 2026 for further consideration.
Right.
I'm allowing it on the next date if you don't produce it.
Not sure. Just
Along how much time it has gone? When did you apply?
Lordship,
on 10/6/2020.
And what is the value at which you are going to sell it?
20.
There must be an agreement. How much? 1 crore? 1 kata is 1 crore nowadays. Okay, revenue village, there will be 40 lakhs. 40 lakhs. So 40 lakhs, if it is 2 years, interest thereupon at 11%. Circle officer will pay from there revenue in the meantime. That will likhi dibo, huh? Pending the next date, it shall not be a bar for the circle officer to provide the no objection certificate. The respondents to provide the no objection certificate to the petitioner upon production of a certified copy of the present order before the circle officer, Dispute Revenue Circle. Else,
Lordship,
get ready to pay that.
Lordship, it fix it
Second,
March.
no? So on that day, be ready for on 40 lakhs, 11%, 11 na? Into for 2 years. So 11% will be 4 lakh 40,000, 8 lakh 80,000. It will be compounded. Ask the circle officer to get it ready.
Town Post brought it, the State Bank of India.
Yes, State Bank Standing Council.
No, your lordship is indisposed, so he could not be present today.
You are
I'm appearing for the Reserve Bank.
Reserve Bank. Who is indisposed?
Mr. J. Borua. Mr. J. Borua.
Is a standing council.
Yes, your lordship, for the State Bank.
Is he a standing council or panel council?
Lordship, he is a panel.
Why haven't you filed affidavit?
Lordship, we need some time. We need some time to file the affidavit.
Notice has been issued almost 6 months back.
Lordship,
Tell him, I have fixed some matters on 27th of February.
Lordship.
Tell your State Bank, in those matters, affidavits have to be filed. This can't happen. This person at 71 years old have lost his money. Tell.
In the Lordship, they have this, they have not returned my ATM card also. The ATM card went inside the ATM machines. That complaint is specifically made. Thereafter, the money was siphoned. In spite of that, they have not refunded it, Your Lordship. And there is a judgment passed by Your Lordship of this court in Forest data, wherein Your Lordship is immediate liability and the liability of the customer in respect to what. And in that case, Your Lordship has directed to.
But that matter went to the division bench.
Division bench has although state the matter, but
The division bench have directed the single judge to again reconsider.
But that matter was compromised, Your Lordship.
Then I said that the division bench cannot direct that.
Yes, sir.
Remand. So I said that I'm not going to take up the matter. I think Justice Manish Chaudhary disposed it of.
Yes. Finally, that matter was compromised by the
petition.
But that judgment has covered the entire things, Your Lordship.
Anyways, whatever may be. Why you are not filing affidavit?
Lordship will file at least a week's time
Next
may be
week.
permitted. Lordship.
Ms. So-and-so appearing on behalf of the State Bank of India and Mr. So-and-so who appears on behalf of the Reserve Bank of India submits that they will be filing affidavit within 2 weeks. List this matter again on 18th of March 2026. Affidavit be filed on or before 13th of March 2026.
Obliged, Your Lordship.
Happy 1947, extended to pay.
Probably the other side has appeared, my lord. My lord, the entire stand is this, my lord. This is a temporary arrangement, my lord. That's why, my lord,
Bring him back. See, if you want an order, I can pass an order. Why don't you bring him back? If you are saying it to be temporary, why do you suffer a judgment from the court? I can very well pass a judgment. There's no problem with me taking into account what is being given out here by the National Health Mission. With these instructions, you cannot help it. And apart from that, earlier what has been stated is, you see, what the problem is, when a person is being working out there, if you don't protect them,
Well,
some people don't like him. I'm not saying about the minister, but others, they may not like him. So you throw him out, put him. The morality of the person gets lost. Yes, if he has done something serious, take disciplinary action against him or do something to that effect. Yes, there are serious allegations for which we don't want. What is it? A section of the people from social leadership, what is this? Has pressurized for his deployment. Tell me. It cannot be in the interest of public service.
it's a temporary arrangement, not a transfer. That's
So
what
therefore, he has only 8 months left.
Lordship,
And I don't think he has a problem also. Bring him after 8 months. If he wants so much at this place, where is this place?
Within the same district, it's not that much.
Understood. Where is he?
It's
He is in this place.
Mukalmwa, block PSC.
These were all interchangeable, na?
Yes. Intra-district, man.
You see, Bimal, what is the name of the petitioner?
Suleiman Hussain.
Huh? Suleiman Hussain. He has been transferred from BPC Somota to BPC Mukalmua. And this person has been sent from Mukalmua to Somota. Same. So, yeah. Why, you see, as you are saying it to be temporary, why do you take a judgment from the court?
You will direct them to take a call on the representation.
But then the query of this court was if there was a violation of the mission director's order, Your Lordship, and that query hasn't been answered yet.
Madam, I also understand that. You see, one has to also understand. If certain things you have to use it in such a manner, yes, if it is if I can get this thing resolved through them, it is better. Instead of for me, it will take 15 minutes for the passing a judgment out there. With these reasons, I'm not at all satisfied. And apart from that, what documents he has placed on the last occasion, which I have kept it on as X, where it is being mentioned that Joint Director of Health Service, as per the directions received from the Honorable Minister Chandra Mohan Patwari, the transfer order is put up for your further direction. So for me, it is not a problem. But then also, when a person is working, if they can take a call on the representation and report back to this court next week. Would you do that? Or I'll pass an order?
I will convey to them and let it be on Wednesday. At least I can have the instruction.
Not this Wednesday. Next week.
Next week.
Next week, next Monday.
Well, Monday.
In the meantime, he has submitted a representation. Na?
Yes.
You may take a call on that.
Lordship.
If you want that handle, I can give it to you.
Lordship. And Lordship will make it on 25th. 25th. At least we get 10 days time to.
Okay, 25th. Pursuant to the directions passed by this court and steps taken, the respondent number 4 is duly represented by so and so. So this court have taken into account the materials on record, including the instructions which have been placed today. They say the instruction is kept on record and marked with the letter Y. Taking into account the above instructions, and the fact that the petitioner have already submitted a representation, this court, before passing any decision in the instant writ petition, would give an opportunity to the respondents, more particularly the respondent number
2, my lord, respondent number 2.
Respondent number 2 to take a call on the representations so submitted by the petitioner on or before the next date. List the matter on 25/2/2026 for final disposal at 2 p.m.
Just up to 435. Report of the legal individual matter. Just 35 below contravention matter.
It's against the report, my lords. The APDCL has preferred an appeal, my lords, before the principal secretary under section 162 subsection 2, my lords.
Then you have filed an appeal.
Yes, my lords. The appeal has been filed on 13th, my lords. 13th of this month.
So as per you, have you filed an affidavit here?
Because we have not filed an affidavit, my lord.
If you have not filed an affidavit, why on earth the petitioner herein would not be entitled as per regulation 5? He's not asking for a huge amount, he's only asking for the 4 lakhs.
That
apart from that, if he has to get any further amount, that will ask as per 9, which he is expert in asking.
Well, otherwise the statute provides for an remedy for an appeal, my lords. We prefer that appeal. But the direction may be issued, my lords, to the principal secretary to dispose of the appeal in a time-bound manner, my lords. That would perhaps suffice.
To
to the principal secretary.
Absolutely no. You want to put your gun in his shoulder and shoot.
No, my lord.
It's something like that.
No.
You have filed an appeal before somebody against an order which is in his favor, and you want that I pass an order in his writ petition, then kindly dispose of that.
Because my lord, otherwise the issue will, the statute, if my lord kindly sees section.
It's a welfare provision. You should pay.
I understand, my lord. I bow down to that, my lord, but section 166 to 162, my lord, subsection 2.
Tomorrow, if it is there, don't pay any further. What is, you have not filed your affidavit?
In the
denying to the contents?
My lords, the moment the inspector's report has come, my lords, we preferred an appeal, my lords.
Report came long time back.
Yes, my lords, on 8/1.
Huh? 16/12/2025.
Yes, 16/12, the affidavit
you
was.
filed appeal on 13/2.
Yes, and the my lords will kindly see the accident in question is of 2017. Now the inquiry they have conducted is in 2025, my lords, and the people that they have interviewed, the statutory mandate is, my lord, moment an accident of this nature occurs.
Okay, well, don't worry, we'll give you the interest.
Very well.
And 4 lakhs, they are entitled from interest from when? From the date of the accident, na?
From the date.
From the date of the accident? First 60 days of the date of the accident?
Yes.
120 days, thereafter 9%, na? 12%. Let them have it. Okay. Mr. B. Chaudhary, appearing on behalf of the APDCL, submits that an appeal has been filed against the report of the Chief Electoral Inspectors dated 16/12/2025. Be that as it may, it is very pertinent to mention that there is no affidavit in opposition filed by the PDCL denying to the allegations made in the instant petition. However, at the request of Mr. B. Chaudhary, the matter stands adjourned. Mr. So-and-so, the learned counsel submits that this would only delay submits that the respondent in PDCL are delaying the disposal of the instant writ petition. It is observed that the delay, if caused by the petitioner, by the respondent, can be very well compensated by awarding interest as is provided under the Assam Electricity Regulatory
Commission, AERC. my lord.
so and so regulation. Regulation. This the matter again on 18th of March 2026.
If my lord's a direction to that effect, my lord, they just keep sitting over the.
No, let it be there for 10 years. You will get up to 12 years. 12%, na? That is why I put it.
1931.
Then one fine day, 4 lakhs will be 8 lakhs.
My lord, affidavit was ready, my lord, because copy could not serve. That's why, my lord, it was not filed. But public copy now he has received, my lord. Admitted amount.
Have you filed affidavit?
My lord, it was ready, my lord. I couldn't serve him the copy. That's why I couldn't file it. But it is ready, my lord. I have already served him
It
the
is
copy.
admitted?
Admitted amount is, my lord, not 65 lakhs. It's 62 lakhs 55,636, my lord.
Ito আমার এই paragraph to quote করি, disposed. Hey, Mr. Counsel, today, without uttering a word, you got 2 writ petitions disposed of in your favor.
1932.
Gan affidavit kon lagai dibo na. Original kon loi anibo. Paragraph to say kori. Yes, Mr. Roy. Ms. Roy, you wanted an upgrade. Tell me. Caste certificate cancelled.
No inquiry report was furnished to me. Yes, filed affidavit, but they did not.
Without following Madhuri Patel. That's your ground.
No inquiry report was furnished.
Yeah, they have a big problem out there. They don't think as per Madhuri Patel, as I could see earlier when I was taking up another matter. Anyways, what to do? Have all the affidavits been filed?
They have filed affidavit, my lord, and they
You file your reply.
not deny my allegation that they did not punish me after the report. No reply was given on this parameter.
No reply is given.
No, my lord. We have said that time and again, show cause notices were issued to her, and then she was called during the course of the inquiry. She avoided throughout and didn't attend the process, and now they are challenging this, my lord. That is the stand taken.
Madam, you file your reply. You see, the reason is if the matter before this court is the almost like a first appeal in view of Madhuri Patel's judgment. So we are therefore to look into it in that parameters. If you don't file a reply and if it has to this effect, then you may be prejudiced. Later on, you cannot say. I can very well say one thing that you don't want to file your reply. Should I close your right?
My confusion, no inquiry report was furnished to her. Because of this, I was prejudiced.
Enquiry made by them. But did you ask for that? Did you ask for that? Then why are you raising prejudice later on? You have to show, na?
Only issued show cause notice, but when the show cause, no inquiry.
Did you ask for the inquiry report? Then
She didn't
file your
appear and
reply.
participate, my lord, in the
Ms.
proceedings.
S. Roy, the learned counsel appearing on behalf of the petitioner submits that the petitioner would like to file a reply to the affidavit in opposition filed by the respondent number 1. When are you going to file the reply? Okay, list this matter again on 26th of February 2026 at 2 p.m. In the meantime, the petitioner is given Miss so-and-so expressing urgency submitted that the reply would be filed on or before 23rd of February 2026. Okay, I'm having it on Thursday, 2 p.m.
1938.
In this case, not if the petitioner owner possesses plot of land or the in that plot of land or if the petitioner had applied for an electricity connection on Lordship 15/11/2025. And the property or Lordship will find the Yadi Patta at page number Lordship 13.
He had applied for a temporary connection, my lords. The temporary connection was given. If I, he,
Page number 36.
pursuant to the last order, my lords.
You have not asked for extension.
He had applied for only 10 days. My lords.
See, initially, Lordship, the Honorable Court has directed to provide the temporary electricity connection on 10/12/2025. They have initially denied. Thereafter, this matter has been listed before this Honorable Court on 5/1/2026.
You asked for 10 days from 8/1/2026 to 7/1/2026.
Lordship, after 10
Where is
days,
your application?
Lordship,
Your application is here. Here it is said that you want the application from 8/1/2026 to 7/1/2026, 10 days.
thereafter, Lordship, we have approached the authority. They
For
have-
extension.
Yes, sir, Lordship.
When?
They have not allowed.
Show me your extension application which was received.
Lordship, that extension application I have not brought in the form of affidavit. Lordship, there Lordship, the submission.
Show it otherwise.
Yes, sir.
Show it otherwise also. I'll give it to you. If Mr. Sharma gives that certificate, extension application by hand also, I'll take it as a gospel truth. Give it.
Lordship, so for the temporary connection is concerned. Lordship,
Ask for extension, they will give you.
Lordship, the only situation is that since my ownership land, there is no dispute before any court of law, Lordship. And that ownership plot of land, what is the difficulty of the respondent authorities to give the permanent connection, considering the application that was submitted on 15/11/2025. In that respect, the respondent authority has not filed, in fact, their affidavit for this honorable court. Case number 36 is the application list.
Yes, why haven't you given him, forget about that, then we are not going to the question of temporary connection.
Yes, sir.
Yes, why haven't you given him the connection if when he has applied? File your affidavit, get your instruction, this is not a case of.
He had applied for a temporary connection, but we've given him.
No,
That-
temporary given, but he's asking for permanent.
Permanent. My lord. That temporary order, my lords, the direction may be issued, will give it, my lords.
No, he can always get it.
Permanent,
He has not asked for it. He doesn't want a temporary now.
but permanent connection will be.
He will only ask for permanent. During this, he wants it before the summers. No? You want it before the summers. Before Bihu, he wants it.
There is
So,
no case pending before the court.
okay. The petitioner herein is aggrieved by the non-granting of the permanent connection, electricity connection, in spite of the fact that the petitioner have supplied all the requisites satisfies all the requisites for grant of a permanent connection. Mr. B. Chaudhary, who appears on behalf of the epidicial, shall provide the instruction as to why the petitioner have not yet been given the permanent connection as has been sought for. List this matter again on 2nd of March 2026 for instructions.
And then the petition shall not be barred to provide connection.
What?
Pendency of the petition shall not be barred to provide permanent connection.
That is always there. They will always provide.
Highly of it.
34, somebody mentioned the
Yes,
matter in the morning.
I
Why?
had mentioned because I entertained my appearance for.
You want to
number
file an
7, 8,
affidavit in
10,
opposition?
My lord, some time may be given, my lord, 4 weeks time may be given to file the affidavit.
Affidavit you are paying for?
Affidavit, please. For
Respond
7,
number?
8, 9, 10.
The matter pertains to?
Repetition matter.
What is he challenging?
an order passed by Divisional Commissioner G. My Lord. This is actually the third round of litigation, my lord. Alia, the High Court has passed an order, my lord. I like to draw attention to page number 106, my lord, where direction has been given to the commissioner to dispose of the representation, but the authority has directed the.
Anyways, Mr. So-and-so appearing on behalf of the respondent number 4, 6, 7, and 8, huh?
7, 8, 9.
7, 8, and 9, 7, 8, 9, 10. 4 weeks time for filing the affidavit in opposition. Full stop. List this matter again on 6th of April 2026. In the meantime, the reply be filed on or before 23rd of March 2026. Affidavit in opposition be filed on or before 23rd of March 2026.
23rd.
Liberty given to the petitioner to file reply thereafter.
I will also file my affidavit.
All the respondents are given. Oh, yes, that one.
Yes.
Pertaining to the age. If it is more than a year, yours is some 1 year. Your birth, if your birth is, you got married on a particular date.
I was married. By the time, as per the current list, I was eligible.
My lord, I am appearing for the asset, my lord.
What?
Assam State School Education Board, my lord.
What
My
do
lord,
you
we
have to say?
in instruction, my lord.
Yes, we sought for an instruction from you
Yes, my lord.
as regards the birth certificate.
Yes, my lord.
I'd like to apprise this court on the next date as to on what basis the proceedings which led to the order was initiated and whether any notice was issued to the petitioner prior to the passing of the order.
Yes, ma'am. My lord, the application of the petitioner was considered, my lord, only on the basis of the birth certificate, and as he is not a government service holder and he intend to increase his birth, my lord, and only on the basis of the birth certificate, his age was corrected, my lord. And thereafter, my lord.
No, the question is, Mr. Counsel, did you inform the petitioner prior to that what is your, or ask him anything? Because he had a date of birth.
Yes, ma'am.
You changed it on your own, on the basis of some complaint filed by somebody.
Yes, my lord. My lord, after passing of this order dated, my lord, 20th November, my lord, he submitted one representation before.
No, forget about his representation. My question is, prior to passing of the order dated 2011-2025, did you put the petitioner to notice?
No, my lord, that was not done, my lord.
There is two options now available. Either this court would stay the order dated 2011-2025 or set aside this order giving you liberty to take action against him. You should notice and then decide.
Yes, my lord, then we'll.
I think you did it at the instruction of Dale. Mr. B. Decker must have been instrumental there. You have some relations out there.
My lord, in fact, there's a whole set of facts which has not been.
Not necessary, Mr. Decker.
I will concede to that point of natural
fact
justice.
remains, I am only concerned. 2011-2025 was passed without informing the petitioner.
True, my lord.
Behind the back. So
I'll bow
that
down to
order,
that, my lord.
there are two options. Either I stay the order, which would effectually delay your adjudication of a proceedings under 111, which you may not like.
Correct, absolutely.
On the other hand, I set aside giving them the liberty to initiate by giving him the notice. Which one do you want?
My lord, we are agreeable to that. My lord, just one thing I must point out, my lord. My lord, there's a whole set of facts which has not been disclosed in the report. Very relevant. What has happened was, my lord, both the petitioner's wife and I had contested for a particular seat, my lord. Thereafter, my lord, of course they won, my lord. Then a complaint was filed saying that petitioner was underage and therefore she suffers a disqualification under 111. Based on the earlier set of the school leaving certificate, the deputy commissioner comes to a finding that the certificates disclose that he was indeed a minor, and removes her from ward member as ward member. Against that, my lord, a writ petition is filed. All that is not disclosed. A writ petition is filed. In that writ petition, my lord, this honorable court orders that she was perhaps not put to notice, so therefore you redo the exercise by taking into account those certificates. Now, while this is pending, my lord, he reaches out to the SEBA, my lord, and says that my the certificates do not record my age as correctly. It should be 1/1/1992 instead of 1/7/1992. And the very basis of those proceedings, my lord, is sought to be behind the back. So therefore,
Behind the back of whom?
My lord, us and everyone.
No, who are you?
My lord,
For his date of birth.
No, I'm the one who's contesting the seat.
Understood, but
Correct.
who are you for his date of birth? It will only be relevant later on.
Yes, correct, my lord. So,
But
so my
for
lord,
the purpose of it, no notice is to be given to you.
True, my lord. I agree to that. My lord, the only problem is I bow down to that ground of natural justice. My lord, may remand it, asking them to. My lord, but now if they use those changed birth certificates to sort of influence that other proceeding, where the proceedings had already taken note of the earlier certificates, my lord. So they basically want an endorsement from the court that the duplicate certificates that were issued, which were changed subsequently merely on an application.
What happened to that writ petition?
That is still pending. They are not appearing. So they changed evidence basically. That's what is happening, and all of that is not
Understood.
So therefore,
what
if
happened
your
to
lordship,
that writ petition?
that writ petition is disposed of, and the deputy commissioner was directed to look into the matter based on the certificates that were available with him. So since the certificates are problematic for them, they reached out to the SEBA and they say that
They got it changed.
they got it changed.
And
Now,
when the SEBA later on, you influence the
yeah,
SEBA.
they
to keep
realize
it
they
against you.
realize it's just not just a day, not just a variation in the birth year or date of birth. It has implications in the other proceedings. So may I suggest, one of the all human, if your lordship may set it aside, send it back, but unless the validity of these certificates are decided by the authority concerned, my lord, if they use these certificates by taking advantage of that order in the earlier proceeding, then it is going to prejudice me, my lord, because these earlier certificates were already taken on.
First of all, I have not made you a party till now.
True, my lord. Which is why, my lord, I'm
That is
seeking
why
an
I have
treatment.
not made. Earlier, Mr. HRHO.
No, no, I'm filling up for him. He's gone to a meeting, my lord. So
therefore I say that I'm not making him a party, that you have no business out there.
my lord will consider my IA at least, my lord. So because ultimately it's not a dispute regarding just merely the date of birth, my lord. It's an election dispute basically. So they want to sort of now gain an upper hand by changing the date and then getting an endorsement from the court, so that in the parallel proceedings they can use them.
Sure.
You may also take one note about the title judgment, also 18 Burma. Actually, it's a 1995 supplementary 3 64 to one lordship, where it is categorically stated the lordship rectification of the date of birth is a matter between a person concerned and the state government, and no other person has a locus standi to prefer a deviate in section. Lordship, in this case, lordship, firstly also I am the petitioner here. I have been prejudiced by the issuance of the order of the Indian order. I don't understand, and moreover, in the Indian order, nothing has been stated about that some complaints have been received from XYZ from students. Actually, it is under their basis, lordship, they have said that my issuance was faulty. They anticipated that it is a faulty, that's why they have cancelled it. I don't see any locus here.
In the IA, we've annexed all the earlier orders, my lord, where the unchanged certificates were taken note.
No, I'll have to pass an order.
My lord.
How do I take care of another situation? You see, there is an urgency also, not for you I'm saying. I set aside this order. Then I say that you have to issue notice to him. Very well. Then you can't serve him. How do you take care of that? How do you take care of that?
Therefore, my lord, petitioner can be directed.
Is the matter tomorrow at 2 p.m. for final disposal? Yes, all other.
55, interim order is still today.
Okay, interim orders will all be extended.
Date may be fixed in item number 55.
All dates will be given by them. They will give it to you. Anybody who wants a
55,
date, all these things.